Hi, everybody. Oh my goodness. Why can't I just learn to leave stuff well enough alone? Oh, I, the clip that I wanted to start with was not done rendering yet. So I thought, okay, not a big deal. I'll just get everything moved down into the basement, because I get banished down here because heaven forbid I stream upstairs, but so so it wasn't done rendering yet, and so I was like, I'll just get everything moved down there, no big deal. Went to, grab the laptop or grab the TV tray that I've got my laptop on, and yeah, because I was, not thinking clearly, I didn't move the coffee and it just went toppled over. Thankfully, it didn't get too much on anything. Just a little bit, like it ran under the laptop, not on it. So that was good. But clips are salvaged. Good news is it in the time of the, you know, spill and cleaning up the spill, it finished rendering. So I get to start with the clip that I wanted to start with. Sorry, there was a small piece of Billy fur that was driving me crazy. Oh, I'm so happy to see you. Oh, you guys are amazing. Live and in person. Yes, yes. But oh, you guys are so great. I love you. All right. Um so I wanted to have some fun tonight. I've got a few I've got where is it? I think it's Georgia. It's either Georgia or Texas to start off. And then go into Florida. And then, depending on how late it gets with those two, I might have Thurston County, but Thurston County wasn't really exciting. It was just, that was actually, if I had to start with that one, that was going to be the most chill. But I also have Fulton County, the state expedited calendar, but I did not have time for that to render because that's like 4 hours. Oh my goodness. Hi, honey. So good to see you. I hope you saw my message. All right. Let's get this a rolling. No, not that one. This one. What do you mean it's in use? Hold on, guys. Oh, that's why it's in use. Okay. I suppose I have to entertain you with my good looks for about, I don't know, a minute, maybe a minute and a half. Oh, whoa, what's happening over here? Okay, hold on. Why? Why does that work wonders? What am I missing? Oh, okay. Okay, we're talking about a baby. Okay. Yes. Now I get it. I get it now, I think. I had to put things together. That is not what I thought we were talking about. So okay. Yeah. You can all see where my brain is broken. Oh, hi, welcome. I'm so happy to have you. Yay. I don't know how. I'm sorry. Oh. I don't know if that's even possible for me. Is this done?
Good morning. I got Michael Anderson.
Okay. Okay. Let's see. I think he was first. Yes. Okay. That works out. Okay. Good morning, council. I'm going to go ahead and call Mr. Anderson and Neosha Payne. If you could both unmute, and we'll go ahead and get things started. So let's see. Neosha Payne. Okay. If both of you could raise your right hands, please. Do you swear that the testimony that you're about to present is the truth and nothing but the truth under penalty of perjury?
Yes.
I'm sorry, Mr. Anderson, has to be audible. I couldn't hear you.
Oh, yes.
Okay, thank you.
Thank you.
Okay, so I am showing that there was a recent payment on October the 10th for $567.80, and the child support amount is the $441 and the $75. So that does take you out of abandonment.
That makes me crazy.
However, we need to figure out how we're going to get these payments to continue, because it appears that it has not been consistent.
Where are you from, Deb?
So, Attorney Majeski, can you tell us what's going on in this case?
Sure, Judge. I mean, this is one situation where, obviously some of this needs better planning, and I'll talk with Mr. Anderson about that. But also some of this is bureaucracy. For example, I'm looking at right here a payment on the 7th where he actually paid $1,500, which is substantially more than he's getting credit for. But I think what happens is when he tries to make a payment for one of his children, he's got several children that he makes payment on, the system just whacks it up among everybody.
That's the way it's designed to work. That's the way it's supposed to work. We can't favor one child over the other. If he has not been paying child support on any of his cases, it's going to divide proportionately.
That's why when you make multiple babies with multiple women and you pay $100 onto your child support, that's how these women are ending up getting child support payment deposits for, $16.59, because it's split up between all of them. Stop making babies, for crying in the mud.
And all of those children have to be supported.
Okay, I understand that. Not asking you to favor any child. I just thought the court should know that, he's trying, and he really is.
Okay. Well, the question now is, what are we gonna do about getting it consistent? Because even if he, didn't pay, the full amount to Miss Payne, she would be getting something if he was making a smaller payment than, say, that $1,500. But there are quite a few months where there's nothing being received.
Buy magnums, Philip.
Yes, I can get on track with that, Your Honor.
Oh, we are open to suggestions.
Or
I'm
finger
sorry.
hats.
Mr. Anderson, you started speaking. You go
Judge,
ahead and finish. Oh, I'm sorry, Mr. Majeski, you go ahead.
Judge, this is a situation. My client has a business that's kind of dependent on weather and the economy. He's a car detailer. Sometimes he's doing really well. Sometimes he's doing not as well because of those two factors. Judge, I can tell you, we've been here before, and he always gets it on track. He always gets it going. So any kind of suggestions or whatever, as long as it's reasonable, I've got no reason to think Mr. Anderson won't do because I've seen him do it before.
Well, the problem is that
So
children. I'm sorry, but what I want to say, and I know Ms. Payne wants to speak
So
as well. Oh, we're having some kind of problem with the audio. The payments for child support have to be consistent because the mother of the child needs to know when they can pay for child care, when they can pay for the expenses that you have in rearing a child. So
Howdy, neighbor.
although it may be applaudable that he's trying to get on track, the best thing to do in a situation where money is inconsistent is to get a second job so that you're going to always be able to make your ends meet. Okay, so Ms. Payne, you go ahead and tell me from your perspective.
Thank you, Your Honor. I would like to say that my order is over a year old. During this time, he's only made about 7 payments. The first payment was for the amount that the judge ordered for 2 of my children, which is only like $409, I believe. But the other time that he's made the full payment would have been in February when he actually had another warrant hearing in a different county. So he was forced to pay a more substantial amount. And for this recent time right now when he has this warrant hearing with me. So it seems to me, because my other payments are only about $40, that's about $20 per child. It seems to me that the only way that he is willing to make these payments is if there's some kind of legal reinforcement. Because I know that we're not dealing with the arrear, but I'm over $7,000 in the arrear. He has another case in this county where it's almost $16,000 in the arrear, and another case in another county where it's $10,000 in the arrear. And these monthly payments are only about, even for the other children, about 100, maybe less than 150 a month. And I know that he's unemployed. I know that he makes good money. Even if I'm able to subpoena his current mortgage, which at a normal rate is only about $3,000, but he's been tripling those payments in order not to lose that home, as well as taking out, I have proof of different
Wait, did I hear that right? That his mortgage is $3,000 and he's been tripling those payments to not lose the home? What? Like that is crazy. Cause yeah, I know what I pay for a mortgage and it's not anywhere near 3,000. That has to be some kind of hella mansion. Yeah, and unemployed but makes good money. That's interesting. There's several interesting ones. I got hooked on this because it's called the Child Abandonment Calendar. And so of course I was like, what's that all about? And yes, glitter fart, when you could not hear me, that was I was just saying love, 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 love. Because Deb is in England and anything across the pond is my heart. Like I love England, I love Australia. Yeah. I don't get me wrong, I do love the US. I'm very proud to be here. We have some of the most interesting people in the world. That's not always a good thing, but yeah, this is my home, and I'm happy to be here. But I have so much respect for other countries, you know. I would love to. Oh my goodness, I would love to. That would be amazing. And you are absolutely correct, my dear. All right, I'm going to hit play again.
Vehicles that he's bought over the past couple of years and more. And the entire narrative, which was why my order was only $400 for 2 children, is that he's been unemployed. That's what he told the judge in my case, and that's what he told the judges in the other cases. But he's not unemployed. He makes way more money than I do, but he's self-employed.
Mm. Okay, so Mr. Anderson, can you explain that? Because it sounds to me as if there is income, but you may be making unwise choices as to how to spend it.
Go figure.
I used to own a car wash location, which now she owns the car wash location. So my income dropped substantially. So I took an option from owning a car wash location to having just a mobile unit, and I'm trying to play catch up at the same time because everything took a substantial drop. But she now has my car wash location, my old car wash location, and a jury company, online jury company. But I try to do what I can do. Like I said, it is weather-based. And
what's an online jury company? Has anybody ever heard of that?
versus me having a location and vehicles coming in, I only have a certain amount of time to go to a different location and do cars. So the income has dropped. And it's difficult. But I am trying to look for other employment, but have been denied.
Okay.
I was going to take advantage of the fatherhood program, which I did before, but even through there, I tried and nothing came out of that.
Ms. Payne? I'm sorry. Okay, Ms. Payne, you go ahead.
Thank you, Your Honor. I would like to bring up the fact that the car wash ownership, it was a joint ownership where my mom invested almost under $100,000 of her personal money to start a business with him. It just recently got transferred in my name, but I would like to mention that I have various court cases with him. The reason that he was no longer the owner is because he was taking all of the money. He was stealing.
Judge, this.
We could call it a jury company, Glitter Fart.
This stuff has been litigated, and if we want to get into court cases and things like that, I think I should also mention that there's been several situations where both this lady and some of the other mothers keep having my client arrested on various different warrants.
For real.
Most recently was trying to say that he committed felony abandonment, and he's never left the state of Georgia. I mean, I personally have tried a case with this particular mother right here, but I don't think anything's really useful. I don't think anything is really useful as far as talking about how we're going to get this child support payments caught up.
Well, we do have to get, I can't deal with the arrearage, but yes, we do have to deal with child support. That's the whole reason that we're here. And he would not, a felony warrant or a magistrate court warrant would not be successful if he had paid his child support. So that's really not an issue. We need to get these child support payments caught up.
Hi, Brian. Hi, Jay. Hi, Michelle. I'm happy to have you guys all here. And I think I just did I think when I hit the pause button, I did the back thingy on the timer. I'm so sorry. Bear with me.
One of his cases, he owes $12,000 on. He's supposed
I am trying to look for other employment, but have been denied.
Okay.
I was going to take advantage of the fatherhood program, which I did before, but even through there, I tried and nothing came out of that.
Have they said this
Ms.
already?
Payne? I'm sorry. Okay, Ms. Payne, you go ahead.
Thank you, Your Honor. I would like to bring up the fact that the car wash ownership, it was a joint ownership where my mom invested almost
Okay,
under $100,000
We'll just have
of her personal money to start a business with him. It just recently got transferred in my name, but I would like to mention that I have various court cases with him. The reason that he was no longer the owner is because he was taking all of the money. He was stealing.
Judge, back to this stuff has been litigated, and if we want to get into court cases and things like that, I think I should also mention that there's been several situations where both this lady and some of the other mothers keep having my client.
As it was discussed last night, Bad Scooter, Lawyer Kitty and Tech Kitty and Ava's the intern. They all have a firm. So if we are doing an online jury company, then they are part of the head firm. So I'm just letting y'all know that right away.
Arrested on various different warrants. Most recently was trying to say that he committed felony abandonment, and he's never left the state of Georgia. I mean, I personally have tried a case with this particular mother right here, but I don't think anything's really useful. I don't think
Start
anything's
on Monday.
really useful as far as talking about how we're going to get this child support payments caught up.
Well, we do have to get, I can't deal with the arrearage, but yes, we do have to deal with child support. That's the whole reason that we're here. And he would not, a felony warrant or a magistrate court warrant would not be successful if he had paid his child support. So that's really not an issue. We need to get these child support payments caught up.
And if I could offer what Ms. Payne was saying is accurate. He has 3 other cases. One of his cases he owes $12,000 on. He's supposed to be paying $403 a month. $264. That $1,500 that Attorney Majeski referred to, $403 went to that case. His other case, he's supposed to be paying $180 a month. He owes $13,000. That case got $309 from the money Mr. Majeski referred to. And the last case, he's supposed to be paying $135 a month. He owes $12,000. That case got $230 from that $1,500.
Whoa.
Okay. And to your knowledge, that looks like that's an appropriate division of the money. It's not there's no errors. That's just the way it has broken down. So
I haven't done specific math on it, but yeah, the lower the child support amount, like the last one, he's supposed to pay $135 a month. That one only got $230 because it's a lower amount that's owed in initial support.
Okay. And are any of these children about to reach 18 or they're not?
Take a look at that. Let's see. Looks like, yeah, that one for 135, that child was born in 1993. So that's when, I guess that one is arrears only. Okay. This one, 35. This child was born in 2009. The one that he's supposed to pay 180 on. And the last one, that child was born in 2015.
Well, isn't that one for the child that's already over 18, isn't that one a bit, I thought that they reduce it very low in order to take care of current support.
Yeah, they do.
As the
They get,
priority.
right, they get the scraps of, after the other have been paid off, which is probably why that one only
He's
got
got a
230 out of that
long
amount.
way to
Yeah.
go.
Right.
Okay. Well, it sounds to me, Mr. Anderson, you've got quite a few more years of having to, pay a significant amount of child support every month so that these children can be taken care of. If this situation, it can't pay that kind of money, you really are going to have to look at another job, either working two jobs or just another line of employment, because this is going to continue to happen. And when the children each reach 18, it
happy
does
you're
not
here.
go away. And I certainly hope that you're not doing something, like tripling your mortgage payments to avoid child support.
No, not at all.
Because that certainly wouldn't be acceptable. Ms. Payne?
Yes, ma'am. And I know that we are focusing
Yep.
on my children, and that is my main focus as a mom.
Mm-hmm.
However, I would like to mention there are a total of 14 children, 2 that are.
I think you're right, but online jury company has been so much more fun to work with. And did she just say 14 children? Oh,
Under the age of 2. So he just had one additional, and all by different mothers. One child was just born in July, and another one was born over a year ago. So it's like a continuing cycle, and no respect for just the life that he's bringing into the world and supporting them.
Ew.
Okay, so Mr. Anderson, you're fully aware of your responsibility at the time when you're continuing to have children. That's, I mean, and then you're coming to this court represented by counsel, which costs even more money to tell me that, that you have a seasonal business and you just can't do it. And that's just not fair to these children.
Judge, Mr. Anderson's an old friend of mine. He's not paying me a dime.
Okay, well.
He has paid me legal fees in over 12 years.
Okay, well, but something has to happen. I mean, are you capable of working another job, Mr. Anderson?
Yes, ma'am. Yes, I am.
Okay, because that's what I would recommend in this situation, because you're going to have to keep paying probably at that rate of about $1,500 a month in order to not end up in this court.
With
So
14 kids, you best
it is what it is,
jobs.
and you're going to have to do something so that you're not going to be in this situation, not just with this mother, but with all of them. It's going to continue to happen until you get the situation straightened out. Okay?
Okay. Thank you.
So for right now, because, you did pay before this court hearing, and you don't have the entire amount of current child support in arrears, this is not an abandonment issue, but I am going to reset you for a future calendar, because we're going to have to keep evaluating this until we can get a change in this situation. Ms. Linear, can you tell me what let's see, this is October.
I'm sorry. I subscribe to that whole logic that when you sleep with someone, you are sleeping with every person that they slept with. So when you do the math on that, it's just icky. And any woman who lays down with a man that is laid down with at minimum 13, 14 other women, that's just too much. You're doing too much. You're simultaneously doing too much and not enough. Like, you got to take care of the babies you're bringing into this world. And if you can't afford the children you're having, you stop having them. End of story. A vasectomy would be a hell of a lot cheaper. And then you could whore around with whoever you wanted to. And then the only person you're putting at risk is, well, yourself and the women that get on their backs for you. But to be bringing innocent lives in the world like that and then just letting them fend for themselves, no, man, no, you're gross in so many ways.
What is the second Friday in November?
November the 10th.
Okay, so I'm going to reset you for my calendar. Wait a minute.
Them's good people.
How did I do that? Yeah, my
I'm
calendar.
sorry. Excuse me, Judge. Correction. Your calendar is November the 17th.
Oh, okay, good. I was just wondering because I thought that was a different judge's calendar. Okay, November the 17th is going to be your reset date. And on November the 17th, I'm going to be looking to see if you've made that payment for November, because we're going to have to keep this going, and you're going to have to keep paying, at that rate so that we can see some consistency before I can dismiss this case.
I'm not a fan of Planned Parenthood by any means, trust me, but I will say they give out free birth control. They have fish bowls of condoms when you walk in, and they are in every major city that there is. And they also give you the Plan B pill for free. And they do free STD screening. He might want to consider paying them a visit. Seriously. Or at least them women he's laying down with might want to consider paying them a visit. But seriously, trust me, I do not like Planned Parenthood, but I will give them the credit that they do. They give free birth control, free condoms, free Plan B pills, anything that you want to make sure that you don't bring a child into the world. They do offer that.
Okay.
Okay.
Any questions from either you or Mr. Majeski? No? Okay. Then I am going to dismiss the parties in this case. You are free to go.
Thank you, Your Honor.
You're
Thank you.
welcome.
Thank you, Judge.
Someone's
You
driving.
too. Thank you for your service, Mr. Majeski. Okay.
And Tiffany does have a shirt on. It's just a skin-colored tank top.
Next one on the calendar is Bernard Boston, Pamela Hicks. I think. Okay, yes, we do have both parties. Mr. Boston, if you could put your face in the frame of the camera, and I need both of you to raise your right hands. Do you swear that the testimony that you're about to present is the truth and nothing but the truth under penalty of perjury?
Yes.
Mr. Boston, if you could remove your mute so that I can hear you.
Spider, praying mantis,
Yes.
beetle.
Okay.
You got to give me more.
Okay, so in looking at this case, I see that there was a small payment on the 3rd of October. Well, it looks like it's a weekly payment. Actually, is Ms. Carson, are the amounts being paid, are those being paid by an employer?
They are, yes. And there was another payment on 10/17 of $76.42, also by income deduction.
Okay then. And Ms. Hicks, are you receiving those monies?
Yes, I have received those.
Okay, so I believe that everything is in order now with your case, Mr. Boston, and we can go ahead and dismiss this. Now, of course, I see that there's a large arrearage, but that you're going to have to do through Superior Court. But as far as current support goes, we typically dismiss once the income deduction order is in place. Okay?
Yes.
Are there any questions?
No, I just want him to make consistent payments. I thought he was just making his payment because we was at court, because we had a court date
Get home
coming.
late. You miss Biggin, but you get me.
Okay, well, thank you to both of you, and you know, hopefully we'll be able to maintain this consistently. Thank you, Mr. Boston.
Yes, ma'am.
Both of you are dismissed. You're free to go.
It's when I laugh after I drink that it's a problem.
Okay, next I have Trevor Carr and Tawana Davenport. Let's see. Is Miss Davenport here? Oh, there you go. Okay, if I could have both of you raise your right hands, please.
Too.
Do you swear that the testimony that you're about to present is the truth and nothing but the truth under penalty of perjury?
Yes.
Okay. So in this situation, I do not see a recent payment for you, Mr. Carr. Has there been one made that just hasn't hit the court file yet?
No, ma'am. I was gonna make one soon. I haven't been working.
And is there an issue with you working? Because that's typically not a good reason. You know, you have to find a job.
Yes, ma'am. It has been an issue because, like, with me standing after this last car accident I was in, like, my leg keeps swelling, going up and down. Still have blood clots in my leg. So, you know, it's like touching base. My doctor don't want me to do too much moving, but I know I got to get a job because I have other responsibilities.
Become a YouTuber.
Like, so they don't want the blood clots to shift until the medication kick in and they gone. So.
Okay. Now I do see that in May, Ms. Carson, is this accurate? There was a payment of over $27,000.
For Mr. Carr, yeah, that's what she's written down. Let me verify that.
Mr. Carr, did you make a large payment, or was income tax or something?
No, it was a large payment made.
Yeah, it's showing up. The payment source is R, and I'm not familiar what R is, but I can see. Did it have something to do with the accident, insurance?
Yeah, it was most definitely that.
Okay. Ms. Davenport, did you receive those monies?
Yes, ma'am, I did.
Okay.
Yes, ma'am, I
Okay.
did, but it still don't stop him from paying. I knew he was gonna bring that car wreck up involved. That car wreck been over 2 years ago, ma'am. His father died, left him a large sum of money. He keep going to dealership buying Audi cars. He done read 2 Audi cars. He done bought back to back, so he don't have no reason not to pay, ma'am. I know my baby, she'll be 18 years old next year, but still he keep calling her, telling her he gonna do this, do that for her, and still she be sitting around waiting on him to come. He never show up. He came and got her like 2 weeks ago to go see a new baby that his other girlfriend done had.
He's wrecked 2 Audi cars. And he's talking about how after this last car accident that he had, he's got such severe injuries and that he can't work. It sounds like he's turned wrecking cars into a job just for them insurance payments, is what it sounds like.
Judge Travis, he just not trying to do nothing. Don't let him get up there and tell y'all he is not. He could work. He can work.
Okay.
You'd get that in a weekend.
So
I mean, me working is her opinion, but my doctor saying something else.
Okay,
so you got proof of that?
Okay, Mr. Carr, what you're going to have to do is you're going to have to present paperwork with regards to that. Because, you know, the court is going to have to be able to verify so that, you know, we know exactly what is going on. So I'm going to put you back on my calendar as well for November the 17th. At that time, I want to see that you have made a payment. You have a very low child support. $264 really is not anything for, you know, for you to be able to do. I mean, that's literally less than $50 a week, and you would be, well, a little bit more than that, but you know, it wouldn't take a lot of money for you to get caught up on this child support. And then it appears that you probably have made a significant effort towards reducing your arrearage as well. So you only have $1,600 in arrearage. So it really would not take much effort at this point if you got a job to get your child support under control. So I would suggest that you do everything to work towards that.
Mister, you can have a seat if you don't need an interpreter. All right, Mr. Let's see. Your Honor, may the interpreter be excused?
If y'all didn't catch that little mini break screen there, the video is unavailable. That is what happens when they cut the stream. So remember I was talking last night, for those of you that were here, that sometimes I'll get into it, you know, 10, 15, 20 minutes late, whatever. And I'll start at the beginning, and when it ends, a lot of the courts, and especially that one, they cut it immediately to prevent people from recording it and reusing the content. So when I get those, I have to get right on them. This is another one, Florida. They are notorious for cutting their stream immediately. So I'll probably have that message at the end of this one too. I didn't heavily edit these because usually these 2 dockets don't have a whole lot of addresses and phone numbers in them. So I didn't, we're just going to roll with this one. I don't know what we're going to find here, but he's usually pretty darn good.
Yes, sir. You may be excused. Thank you, Your Honor. Mr. Meadows, you ready?
Yes, Judge. Mine's going to be the quickest you'll do all day, Judge. I got to sign VOP form in which the violation is dismissed and is reinstated.
No objection.
Wyatt, State of Florida versus Wyatt Putney.
You're not objecting.
That's correct. The state would dismiss the violation.
All right. Violation. Thank you. All right. Mr. Henson, are you ready?
Almost, Your Honor.
Okay, Mr. Meredith?
Might be in my rotation.
I'll get to you just a minute, Mr. Gomez. Excuse me. Who'd you call?
Pryor, P-R-E-Y. Have a seat, sir.
Too many cover him. I love him, but
No, it's not.
everybody already does him.
Well, he was in the 30s.
Landlord tenant docket.
I need to point that information. 48 days. I have no charges.
This is Dalen Prayer. This is case 22-2017. He would acknowledge
I fly by
willfully
the
violating
seat of my
charges of
pants.
supervision by having contact with law enforcement.
But get a hold
Those
of me.
charges in Alabama, however, are in the process of being dismissed. They're current right now because he hasn't signed a release, and the clerk has not gotten his family the monetary court costs that they're requesting. The agreement with the state is that adjudication will continue to be withheld and the supervision be modified to extend it to a total of 48 months from the original sentence date. That's increasing it by 1 year. He'd have a curfew 7 p.m. to 7 a.m., which would be adjustable for work schedule. There's additional $250 cost of prosecution, and all prior conditions are reimposed to the extent they remain incomplete or modified by this sentence. Again, this is just a best interest plea to get him back home to Alabama.
Please teach me.
All right, sir, you can lower your hand and state your name.
Dalen Prayer.
Mr. Perry, you heard the announcement of Mr. Meredith. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
Sir.
Are you under the influence of any drugs or alcohol today, which would affect your ability to enter the agreement or understanding the terms and conditions of it?
No,
We've
sir.
seen
I've
that
been handed a
before.
violation of probation community control plea form. There's a signature over the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your violation with Mr. Meredith?
Yes, sir.
Have you had sufficient time to speak with Mr. Meredith about your violation? Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by admitting you violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing? You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses you may have to the allegations. You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify or remain silent at the evidentiary hearing, which would be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Mr. Prayer, do you feel the admission is in your best interest?
Yes, sir.
All right, and I'll accept the stipulation that there's a basis for the violation. I'm going to find the admission was freely and voluntarily made. After consultation with his attorney, I'm going to accept it. He is reinstated.
COVID. Biggest
It's
example.
extended 48 months from the original. His term of supervision extended 48 months from the original sentence date. First 12 months will be on a 7 p.m. to 7 a.m. curfew, can be adjustable for a work schedule. There's an additional $250 imposed a day for the cost of the prosecution. All other conditions are reimposed. I'll maintain the withholding of adjudication of guilt. Mr. Prayer, you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, sir. Need to step over and speak with the probation officer.
Kenneth Brown. Kenneth Brown is before you on a preliminary violation. The state and I are both requesting and have made the request they be screened for Keaton.
Okay.
I believe if he's accepted, he's okay with that.
All right, I'm gonna order that he be screened for the Keaton House, and we'll set this for November 22nd at 9 o'clock for a preliminary hearing.
All right. So screen in.
All right, Mr. Gomez, you here for Mr. Stowe?
Yes, Your Honor, that's correct.
It says, Mr. Stowe present. Is Mr. Pack here?
They gotta save
Where's
the big
Mr. Pack
box.
at? Y'all know? Is he outside? Ms. Jewel, do you know if Mr. Pack's outside or where he's at? Well, I don't know. Mr. Gomez, are we going to have are we set for are we going to have an evidentiary hearing today?
So as of right now, I had reached out to the probation officer, in this case, Officer Stanzioni. She had met with Mr. Stowe on Monday, and Mr. Stowe had relayed to her that he was going to be paying $4,500 into the clerk. And if he did that, we would not need an evidentiary hearing. And I was really hoping that I would kind of log in today and Mr. Stowe would be here and would maybe have paid it this morning, or was going to pay it maybe after the hearing. I don't know. But I haven't seen that happen. And if it doesn't, then I think we're prepared to move forward. I do have Officer Stanzioni that is ready to appear via Zoom this afternoon at 1:30 p.m. In the event that we need to do that, and I will be present in court. However, I would.
Well, let's just hang on just for a second this morning. I don't know where Mr. Pack's at.
Yes, sure. That sounds good. I have no issue with that. I kind of cleared my schedule this morning to wait, so I have no problem waiting.
All right, we'll see when he was here this morning. Is that correct?
Yeah, for a brief time.
Was he going to stick around? All right. Well, if we see Mr. Stowe or Mr. Pack, we'll call you back on. Mr. Henson, you ready?
Thank you, Judge.
Mm-hmm.
Your Honor, this is a Colby Lee Edmondson, case number 2332.
All right, Mr. Edmondson, come on down.
Sorry, case number 3. And we're taking
that's on the wild docket.
Yes, I have case number 23 now.
You're right, 941. Your Honor, we're doing a plea for this is grand theft for 24 months probation, court cost fines, and restitution may be assessed. The court costs and fines, Your Honor, total $1,253, and there's 4 days jail time credit will be awarded. $20 cost of supervision. We have additional penalties from DHS and V, and stipulates the facts probable cause affidavit for the prima facie case, and agree to imposition of minimum cost prosecution. DNA sample, forfeit seized items, agreed to a mental health evaluation and counseling is recommended, and no contact with any victims.
That's the agreement with the state?
Yes, Your Honor.
So this way the testimony you're about to give us the truth, the whole truth, and then you but the truth, so help you God.
Yes, ma'am. All right, sir, you can lower your hand and state your name.
Colby Edmondson.
Mr. Edmondson, you heard the announcement of Mr. Henson, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir, Your Honor.
Anybody promise you anything different?
No, sir, Your Honor.
Are you under the influence of any drugs or alcohol today, which would affect your ability to enter the agreement and understanding the terms and conditions of it?
No, sir, Your Honor.
I've been handed a plea waiver consent form. There's a front page. On the second page, there's a signature of the defendant. Is that yours?
Yes, sir, it is, Your Honor.
You had a chance to read that agreement?
Yes, sir, Your Honor.
You had a chance to go over your case with Mr. Henson?
Yes, I have, Your Honor.
Have you had sufficient time to speak with Mr. Henson about your case?
Yes, sir, I have, Your Honor.
Are you satisfied with your lawyer's advice and counsel?
Yes, I am, Your Honor.
Do you understand that by entering the plea, you're waiving your right to go to trial?
Yes, sir, Your Honor.
You're waiving your right to require the state prove the allegations against you?
Yes, sir, Your Honor.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir, Your Honor.
You're waiving your right to present any defenses you may have to the allegations?
Yes, sir, Your Honor.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf?
Yes, sir, Your Honor.
You're waiving your right to testify to remain silent at the evidentiary hearing, which will be your decision to make?
Yes, sir, Your Honor.
You're waiving your right to appeal anything but an illegal sentence?
Yes, sir, Your Honor.
Are you doing this for your own free will?
Yes, sir, Your Honor.
Mr. Evans, do you feel the pleas in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir, Your Honor.
And Mr. Henson, did you stipulate the prima facie case?
Yes, Your Honor.
All right, Mr. James and Mr. Henson, the state of the defense aware of any DNA evidence that exists which might tend to exonerate Mr. Colby.
No, Your Honor.
I am going to find as a prima facie case. I'm going to find that Mr. Colby's plea, Mr. Edmondson's plea, was freely and voluntarily made after consultation with his attorney. I'm going to accept it. Adjudication of guilt is withheld as to the grand theft of a motor vehicle. He's placed on a term of probation not to exceed 24 months. Fines and costs. What's that amount? $1,253. I am going to reserve on restitution. He must complete 50 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I will give the Florida Department of Corrections the discretion to amend that to at the direction of a probation officer. Department of Highway Safety and Motor Vehicles may apply additional penalties.
Your Honor?
Yes.
The community service was marked out.
All right, we'll mark out.
For mental health.
I'll mark that community service work out. If he's required to give a DNA sample, he must submit one to forfeit all seized items. He must undergo a mental health evaluation within the next 30 days, maintain employment at least 30 hours a week, or show proof of 3 job applications per week. Yes, sir. Sir, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you, no charge. Good luck to you, sir. You need to step over and speak with the probation officer.
Thank you, Your Honor.
Thank you, Your Honor. That concludes my business.
I have a good day. See, Mr. Shepard, are you ready on your, we're just putting some finalization. Okay. Mr. Dennis?
Good morning, Your Honor.
Good morning.
I'm here for Sabrina Baldwin. She should be there present in the courtroom.
All right, Sabrina Baldwin?
And Your Honor, she's here for, I think, the initial VOP hearing. I spoke with Mr. James. He's extended an offer. I just need to go over that in more detail with Ms. Baldwin. If we could just get another court date, we can maybe even put it on the next week's wild doc, but we're going to get it resolved.
Is that what you want to do? You want to put it on next week's? All right, we'll put it on next week's wild doc. That's the the 25th? 25th at 9 o'clock, ma'am. If you'll step over and sign a notice.
Yes, thank you.
Oh, that I.
Yes, sir, Mr. Dennis. Have a good day.
Thank you. You too.
This is Mr. Johnson, and coming forward in 214709, he's going to be entering admission to his VOP. His probation will be modified. His probation will be extended to 24 months from his original supervision start date. Additional $250 public defender and cost prosecution fee. All prior and complete conditions not herein modified or reimposed. Special condition, he has an additional $1,781.50 to Bay County Sheriff's Office for transport fee. His violation period, March 10th, 23 to October 17th of 23 was tolled, so that time will be added back on as well. And the next 12 months of supervision is on CC1, so he will be on house arrest.
Yes, ma'am. You lower your hand, Mr. Johnson, state your name.
Terrence Johnson.
Mr. Johnson, you heard the announcement of Ms. Jewell, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning, which would affect your ability to enter the agreement and understand the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your violation report with Ms. Jewell?
Yes, sir.
Have you had sufficient time to speak with Ms. Jewell about your violation?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand you're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses you may have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the evidentiary hearing, which will be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Mr. Johnson, do you feel this admission is in your best interest?
Yes, sir.
You agree you violate the terms and conditions of your probation by having contact with the law enforcement in Texas?
Yes, sir.
I'll find there's a basis for the admission. I'm going to find that Mr. Johnson's admission was freely and voluntarily made after consultation with his attorney. I'm going to accept it. His probation is modified as follows. It's extended 24 months from the supervision start date, extended to 24 months from the supervision start date. The next 12 months will be on community control 1. The violation period of March 10th, 2023 to October 17th, 2023 was told, so that's added back in. The next 12 months will be on community control 1. All conditions that were previously imposed are reimposed. There's an additional $250 imposed today for the cost of the prosecution of the violation for probation. He's also ordered to pay $1,781.50 to the Bay County Sheriff's Office for their transportation cost. So was the original withhold adjudication?
Yes, sir.
What's the agreement?
I'll maintain the withhold of adjudication.
His withhold is maintained. All right, Mr. Johnson, you have 30 days to file notice of appeal if you wish to appeal the judgment sentence. If you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir, and step over. Mr. Pack, have you had a chance to speak with Mr. Stowe today?
I know he paid money.
We're pretty much a support
Okay,
group.
we just had Mr. Gomez and he was waiting. So Mr. Gomez, if you can hear me, Mr. Pack has not had contact with him and Mr. Stowe's not in the courtroom.
Where are you? Are you in there?
He's in the,
Gomez, you up there? No, okay.
he may have it muted.
I know he just paid $6,000 in there. That's, at least it's reflected in your records there.
That was in August.
Ma'am, sit down and step out, please.
That was in August, Judge.
I think he had talked.
Sorry, Judge, I'm the duty attorney for us, and I just got in a call. I apologize.
That's okay. Mr. Pack has not had any contact with Mr. Stowe. He was indicated that there was some money paid in August, and Mr. Gomez had indicated that he had told his probation officer he was going to pay $4,200 today. So I haven't seen him this morning, so I just wait to, I guess, just come back this afternoon and see where we're at 1:30.
Is that your understanding, Mr. Pack?
Yes, I know, I know he just paid the $6,000 and, I don't know if he's gonna show up at 1 o'clock or not here. I mean, it's hard to get a hold of him. I mean, as far as I'm concerned, you can stay on. Go ahead.
Oh, I'm sorry. I just want the court to be aware. He paid the $6,000 before. It was like the day of the last hearing in August. So it wasn't. I just wanted to be aware that it wasn't like he just recently paid that. He had paid that at the last hearing in August, and then he was supposed to pay more to avoid an evidentiary hearing. And he told his officer on Monday that he was going to make a $4,500 payment. When I reached out to his officer yesterday to see if there was any movement on that, she said that she had not seen anything. I mean, if this is going to be a hearing, then I'm going to want to be there. So I will be present at 1:30. Officer Stanzioni will be appearing via Zoom because she's out of Central Florida, I believe, if I'm not mistaken, where he's being supervised. And so if Mr. Pack, if there is any change in between now and then, I have sent you an email that includes my cell phone number, my personal cell, so you can give me a call if you have a contact with him, because I also made an offer to you that in the event that he doesn't pay, we're not trying to incarcerate him for an extra long period of time. We would be okay with trying to maintain that withhold, but having maybe 20 days of jail as a condition of that probation, as well as meeting with probation to set monthly amounts that he must pay as a condition of that probation. That would be how we would want to resolve an admission to the violation in lieu of a VOP hearing.
It's a mobile jury service.
When was that $6,000 paid? You tell?
August 23rd, I believe.
All right.
Yes,
All
sir.
right, thank you, Judge.
All right, Mr. Gomez, have a safe trip.
Thank you.
And I have Molly Andrews. She's coming forward in 22-1983 and 23-3287. As to 23-3287, she will be entering a plea of no contest to count 2, open carry of a weapon, a second-degree misdemeanor. She'll be adjudicated guilty and time served, and her count 1 will be consolidated. As to her VOP, she would, based upon that plea, she would be entering an admission.
We all are.
Be sentenced to 17 months in the Department of Corrections with 55 days of credit. Court costs and fines would be by civil judgment. We would stipulate to the facts on the probable cause affidavit, agree to the imposition of the minimum cost of prosecution. She would forfeit any seized items, and her probation would be revoked.
That's the agreement with the state.
Yes, Your Honor.
Raise your right hand. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth. God. Yes, sir.
All right, you can lower your hand, ma'am, state your name.
Contact
Andrews.
sign.
Ms. Andrews, you heard the announcement of Ms. Jewell, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning,
No,
which would impair your ability to enter the agreement and understand the terms and conditions of it?
Yes, sir.
Pardon?
Yes, sir.
You understand what's going on, but you're not under the influence of anything, are you?
I understand what's going on, sir.
You're not under the influence of anything. Is
No,
that
sir.
correct?
I'm just sick.
I really think they might be under the influence of something with the way they're bobbing and weaving and the way their speech is. Like, I have my doubts. I seriously have my doubts that they're sober.
I don't feel good.
Okay. All right. Well, here's a plea waiver consent form that I've been handed. There's a front page. On the second page is a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your violation report with Ms. Jewell?
Amazing.
As well as the new charge?
Yes, sir.
You understand that you're entering a plea to a misdemeanor on the new charge?
Yes, sir.
And you're admitting that you violate the terms and conditions of your probation?
Yes, sir.
You understand you're waiving your right to go to trial?
Yes, sir.
And you're waiving your right to have an evidentiary hearing on the violation of probation?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir.
You're waiving your right to present any defenses you may have to the allegations?
Yes, sir.
You're waiving your right to
Yeah,
subpoena your own
don't
witnesses
stick
to
in
come to court
jail.
and testify on your behalf?
Yes, sir.
You're waiving your right to testify to remain silent at the trial and at the evidentiary hearing, which will be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Ms. Andrews, do you feel the admission and the no contest pleas in your best interest?
Yes, sir.
I am going to find you stipulated the prima facie case in the open carry. I'm going to accept that stipulation. I'll find there's a prima facie case for the misdemeanor. I'm going to find her plea to the misdemeanor will serve as a basis for her admission that she violated the terms and conditions of probation. I'm going to find her pleas were freely and voluntarily made after consultation with her attorney. I'm going to accept them. In case number 23-3287, she's adjudicated guilty of open carry of a weapon since the time she served in the Bay County Jail, given credit for that time served.
He's making me
On
uncomfortable.
the felony on the 22-1983, her probation is revoked. She's adjudicated guilty of felony battery, sentenced to 17 months in the Florida Department of Corrections, given credit for 55 days time served. All monies previously imposed are not paid or reduced to a civil judgment. There's a $250 imposed today for the cost of the prosecution of the violation of probation. That's also reduced to a civil judgment. Ms. Andrews, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you. You need to step over and be fingerprinted.
Scott Rainey? Mr. Rainey's coming forward in 23-1964. He's going to likewise be entering an admission. His probation will be modified and extended to 24 months from his original supervision start date. All prior incomplete conditions not herein modified or reimposed. He will be maintaining his withhold of adjudication. His new special condition is bars to bed Keaton with aftercare. Balance of supervision will be on drug offender probation and the additional $250 public defender and cost of prosecution fee.
You should apply to be the
That's
next
right.
prison
All right.
fashion.
Strange, state your name,
designer.
please.
All right, Rainey.
Mr. Rainey, you heard the announcement of Ms. Jewell, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning, which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
You were communicating. I need you to leave.
There's a violation of probation community control plea form. Is that your signature on the line?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your violation report with Ms. Jewell?
Yes, sir.
Have you had sufficient time to speak with Ms. Jewell about your violation?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by
Solid
admitting you
color.
violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations?
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf?
Yes, sir.
You're waiving your right to testify to remain silent at the evidentiary hearing, which would be a decision you'd have to make?
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Randy, do you feel the admissions in your best interest?
Yes, sir.
You agree you violated the terms and conditions of your probation by testing positive for amphetamine and methamphetamine?
Yes, sir.
I'll find there's a basis for Mr. Randy's admission. I'm going to find his admission was freely and voluntarily made after consultation with his attorney. I'm going to accept
You
it.
snuck
His
in
probation
here.
is modified as follows. It's extended 24 months from the supervision start date. As a special condition, he'll enter and successfully complete the Keaton Bed program plus the aftercare program. The balance of his supervision will be on drug offender probation. This will be a bars to bed, which means you'll remain in the Bay County Jail till bed becomes at the Keaton House. Any violations of the jailhouse rules or the Keaton House rules, it can serve as a basis for the violation, for an affidavit of violation of probation. All conditions that were previously imposed and have not been completed or reimposed. There's an additional $250 imposed a day for the cost of the prosecution of the violation of probation, and I'll maintain the withhold of adjudication of guilt. All right, Mr. Randy, you have 30 days to file notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you, and you can't afford one, one may be appointed to represent you at no charge. Good luck to you. You need to step over and speak to the probation officer.
Your Honor, I have Delisa Sanders. Your Honor, she was scheduled for a 1:30 evidentiary hearing. I believe Mr. James is going to be requesting a continuance, and we do understand that.
That's correct. This is the case that the victim is tied to a heart monitor, and I'm trying to get the identity of the nurse that found the pills under the pillow. The officer went to the hospital yesterday. I have not heard from him yet as to the identity of this nurse, but I'm asking for another continuance.
We'll set this for set it for December instead of November. Huh? That's November 22nd is the date, isn't it? That's Wednesday before Thanksgiving. Ma'am, we're gonna set it for December.
Okay.
We'll set December 20th at 1:30, and then also at 9 o'clock. If there's any reason to advance on a docket, you can put it on another docket.
I'm sure I'll be able to convince Mr. James.
This is Billy O.T., aka Lawyer Kitty. The love of my life.
Good morning.
Cynthia Galloway. Your Honor, this is Cynthia Galloway, case number 224853, which is a VOP 232200 and 232201. As to all, she withdraws her previously entered plea of not guilty and withdraws her denial on the VOP and enters a plea of no contest as follows. In case number 224853, She enters a plea of she enters an admission to violation of probation based on possession of cocaine, a third-degree felony punishable by up to 5 years in prison, and an admission to possession of hydrocodone, which is a VOP, based on possession of hydrocodone, a third-degree felony punishable by up to 5 years in prison. In case number 23-2200, she enters a plea of no contest to sale of cocaine, a second-degree felony punishable by up to 15 years in the Department of Corrections. She enters a plea of no contest to unlawful use of two-way communications, a third-degree felony punishable by up to 5 years in the Department of Corrections. In case number 23-2201, she enters a plea of no contest to count 1, possession of cocaine, a third-degree felony punishable by up to 5 years in prison. Count 2, possession of fentanyl, a third-degree felony punishable by up to 5 years in prison. Count 3, possession of marijuana less than 20 grams, a first-degree misdemeanor punishable by up to 1 year in the county jail. And count 4, possession of paraphernalia, a first-degree misdemeanor punishable by up to 1 year in the county jail. Pursuant to negotiation with the state, she'll be adjudicated guilty. She'll serve 28 months in the Department of Corrections, pay court costs and fines. She has 132 days credit as of today. She'll be adjudicated guilty in time served on the misdemeanors. She has a DNA sample. She stipulates to the facts in the probable cause affidavit. She agrees to imposition of minimum cost of prosecution and forfeit any seized items.
That's the agreement with the state?
Yes, Your Honor.
Billy was feral.
Raise your right hand. Promise swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth to help you God.
Yes, ma'am.
Ms. Galloway, if you can lower your hand and state your name.
Cynthia Galloway.
Ms. Galloway, you heard the announcement of Ms. MacArthur, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything other than what your lawyers just announced in open court?
No, sir.
Are you under the influence of any drugs or alcohol today, which would affect your ability to enter the agreement or understand the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature. There's the front page on the back, it's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your case with Ms. McCarthy?
Yes, sir.
Have you had sufficient time to speak with Ms. McCarthy about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by entering the plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir.
You're waiving your right to present any defenses you may have to the allegations?
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf?
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which will be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Ms. Galloway, do you feel the admissions in your the plea is in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
All right. And there's no DNA evidence that the state or defense swear, which might tend to exonerate Ms. Galloway. Is that correct?
That's correct.
I can just hear this judge saying, all right, all right, all right. If we were to rewind and play that all right again, it needed 2 more. It really did.
All right, if I can get a prima facie case on the new felonies.
Head case 23 CF 2200 gone to trial, the state would have shown that on June 13th of 2023, the defendant sold cocaine to a confidential informant, and that deal was coordinated through a telephone, which was used to further the commission of the offense. And in case 23 CF 2201 on the same day, June 13th of 2023, following that, controlled by law enforcement executed a search warrant in the defendant's hotel room that was registered in her name and found cocaine and fentanyl.
I'll find there's a prima facie case. I'm going to find that Ms. Galloway's plea to the new charges will serve as a basis for her admission that she violated the terms and conditions of her probation. I'm going to find her pleas were freely and voluntarily made after consultation with her attorney. Is there any reason we can't go forward?
No, Your Honor.
No, Your Honor.
I'm going to accept her pleas. In case number 23-2200, she's adjudicated guilty of sale of cocaine, count 1, and sale of an unlawful use of a two-way communication device on count 2. In case number 23-2201, she's adjudicated guilty of count 1, possession of cocaine, count 2, possession of fentanyl, count 3, possession of marijuana less than 20, and count 4, possession of drug paraphernalia. On each of the felonies, she is sentenced to 28 months in the Florida Department of Corrections, given credit for 132 days time served. Those Sentences will run concurrent with each other. She's assessed fines and cost of $1,078. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment additional court cost, a $150 discretionary public defender fee payment, a $50 drug abuse trust fund payment, and a $200 discretionary fine. The fines and costs are reduced to a civil judgment, and there's no restitution applicable in the case. If she's required to give a DNA sample, she must submit one.
You should go to my videos that when I used to do not live videos, and I did all the clip art and pop-ups and stuff. There's one, I think I called it I Challenge You to Challenge Jurisdiction. He had a SOV sit in front of him. Oh my goodness, it was so glorious because he knows exactly how to put them right in their place, and he doesn't take any bull. Like, he doesn't have time for bull, he'll let them speak their piece, but he's gonna call it like it is.
She'll forfeit any seized items. On the possession of marijuana less than 20 and possession of drug paraphernalia, she's sentenced to 132 days in the Bay County Jail, given credit for 132 days time served. Those sentences will run concurrent with each other and also concurrent with the sentences received in the other felonies. In case number 224853, her probation is revoked. She's adjudicated guilty of the possession of cocaine and the possession of hydrocodone. Each of those she's sentenced to 28 months in the Florida Department of Corrections, given credit for 132 days time served. Those sentences will run concurrent with each other and also concurrent with the sentences received in case number 232200 and 232201. All monies previously imposed and not paid are reduced to a civil judgment. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. That's also reduced to a civil judgment. Ms. Galloway, you have 30 days to file a notice of appeal if you wish to appeal your judgment sentence. If you'd like to have an attorney to represent you, you can't afford one may be appointed to represent you at no charge. Good luck to you. You need to step over and be fingerprinted.
Thank you.
Correct register. Judge Craig registers before you in case 222293. He's prepared to having willfully violated the terms of his supervision by changing his address without notifying his officer and then failing to report. The agreement we've reached with the state is his supervision be revoked. He'll be sentenced to 13 months, Department of Corrections with no probation to follow. There's 175 days credit against that sentence. There'd be $250 costs of prosecution for today's proceedings. That and any unpaid monetary obligations would all be reduced to a civil judgment.
I would think so.
Yes.
Mr. Register, lower your hand and state your name.
Craig Register.
Mr. Register, you heard the announcement of Mr. Meredith. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning, which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your report with Mr. Meredith?
Yes, sir.
Have you had sufficient time to speak with Mr. Meredith about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by admitting you violate the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir.
You're waiving your right to present any defenses that you might have to these allegations?
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf?
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which will be your decision to make?
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence?
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Register, do you feel the admissions in your best interest?
Yes, sir.
You agree you violated the terms and conditions of your probation by moving without permission?
Yes, sir.
I'll find there's a basis for the admission. I'm going to find that Mr. Register's admission was freely and voluntarily made after consultation with his attorney. I'm going to accept it. His probation is revoked. He's adjudicated guilty of the grand theft of a motor vehicle. He is sentenced to 13 months in the Florida Department of Corrections, given credit for 175 days time served, all monies previously imposed and not paid are reduced to a civil judgment. There's an additional $250 imposed today for the cost of the prosecution of
Florida.
probation. That's
14th
also reduced to a
district.
civil judgment. Mr. Rester, you have 30 days to file a notice of appeal. If you wish to appeal the judgment sentence, you like to have an attorney to represent you, and you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir. You just step over and be fingerprinted.
Austin Dent. Mr. Dent's case 22. Oh, reading that now?
1840.
There you go.
Yeah, a lot of them do it at the jail. I don't know why
Mr. Dent is
they're doing it.
prepared to admit having willfully violated
Here.
terms of his supervision. And
The only thing I can think, and I might be wrong on it, but the only thing I can think is maybe they have some kind of a state statute where you're not allowed to be fingerprinted until you're convicted of a crime, maybe. That's the only thing that makes sense to me, because you're always innocent until proven guilty. So maybe once you're proven guilty, then they can fingerprint you. And maybe it's just a state statute that they can't do it sooner than being found guilty. That's the only thing that makes sense to me, but I might be wrong.
a number of ways, including not completing all the special terms of community service work, theft course, and by testing positive. This is a best interest plea. The state has agreed that be adjudicated. He previously was adjudicated.
Bad boy, bad boy.
He'd be sentenced to 13.8 months in the Department of Corrections with no probation to follow. He has 99 days credit against that sentence. There's $250 cost of prosecution for today's proceedings. That and any unpaid monetary obligations would all be reduced to a civil judgment. This is his lowest permissible sentence. I've tried to negotiate anything lower than that or suggest an open plea to the court because he does score under 60 points to let the court make a decision as to what the appropriate remedy would be. But I believe he thinks this is in his best interest.
Very good.
You're just never proven innocent.
Yes, ma'am. All right, Mr. Dent, you can lower your hand, sir, and state your name. Austin Dent. Dent, you just heard the announcement of Mr. Meredith. Is that correct? Yes, sir. Is that your understanding of the agreement with the state? Yes, sir. Has anybody promised you anything different? No, sir. Are you under the influence of any drugs or alcohol today, which would impair your ability to enter the agreement? No, sir. I've been handed a violation of probation community control plea form. There's a signature of the defendant line. Is that yours? Yes, sir. Have you had a chance to read that agreement? Yes, sir. Have you had a chance to go over your violation report with Mr. Meredith? Yes, sir. Have you had sufficient time to speak with Mr. Meredith about your case? Yes, sir. Are you satisfied with your lawyer's advice and counsel? No, sir. All right. Do you want me to accept this plea? Yes, sir. All right. You understand that by accepting the plea, you're waiving your right, or by entering the plea, you're waiving your right to have an evidentiary hearing? Yes, sir. You're waiving your right to require the state to prove the allegations against you? Yes, sir. You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence? Yes, sir. You're waiving your right to present any defenses that you might have to the allegations? Yes, sir. You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf? Yes, sir. You're waiving your right to testify to remain silent at the evidentiary hearing, which will be your decision to make? Yes, sir. You're waiving your right to appeal anything but an illegal sentence? Yes, sir. Are you doing this for your own free will? Yes, sir. Mr. Dent, you feel the admission is in your best interest? Not really, but yes, sir. You agree you violated the terms and conditions of your probation by failing to do the technical or by technical violations of failing to pay money, complete
You know what you want? You want to make yourself a jelly sandwich. And then you dip it into French toast batter and fry it like French toast. So you're just making French toast that's already stuffed with grape jelly. Trust me on this. Or if you have kids and they have Uncrustables or grandkids and they've got those stupid, really super overpriced Uncrustables in the fridge, take one out, put it in French toast batter, and fry it. Trust me, delightful. Absolutely delightful.
Treatment and found it and testing positive?
Yes, sir.
I'll find there's a basis for the admission. I'm going to find that Mr. Dent's admission was freely and voluntarily made after consultation with his attorney. I'm going to accept it. His probation is revoked. He's sentenced and he's adjudicated guilty of the underlying grand theft of a motor vehicle. He is sentenced to 13.8 months in the Florida Department of Corrections, given credit for 99 days time served. All monies previously imposed and not paid are reduced to a civil judgment. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. That's
It's
also
more of a
reduced to a
breakfast
civil
thing.
judgment. Mr. Dent, you have 30 days to file a notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, sir, and you can step over and be fingerprinted.
This is Ms. Baba in case 2018 CF 884. She will be entering an admission to violation of probation. I believe she was previously adjudicated. Her probation will be revoked. She'll be sentenced to 13 months in the Department of Corrections with 93 days of credit. All unpaid monetary obligations will be by civil judgment, including the additional $250 public defender and cost of prosecution from today.
That's the agreement with the state.
Have you never run out of syrup or something and just used grape jelly on your French toast instead? That's not a thing. I do that all the time. I use jelly instead of syrup because I'm not a huge syrup fan. So I don't know. Yeah, I throw it on pancakes too. Yeah, jelly goes good on pancake. You know what's really good? Jelly goes amazing on grilled cheese sandwiches. I know that sounds absolutely insane, but yes, make a grilled cheese sandwich with grape jelly, and it's fantastic.
Ma'am, state your name, please.
Baba.
Ms. Bobby, you heard the announcement of Ms. Jewell, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning, which would impact your ability to enter the agreement or understand any of the terms and conditions of it? Have you taken anything that will
No.
make you not understand what's going on? So you understand what's going on?
Yes, sir. Sorry.
Okay. I've been handed a violation of probation community control plea form. There's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had the opportunity to read that agreement?
Yes, sir.
Have you had the opportunity to go over your violation report with Ms. Jewell?
Yes.
I had to stop my stream last night to educate someone on what Frogger was, and I'm sorry. You did it to me. I got to stop my stream again. I cannot let this go on another minute. You don't know what French toast is? Okay. White bread, and you take 2 eggs and a drop of milk and cinnamon, sugar, and vanilla. And you whisk it all together really, really good. And then you take your white bread and you'll get with the 2 eggs, you get 3, maybe 4 pieces of French toast out of it. You heat your pan up just like you're cooking pancakes. Put spray Pam on it. and then you dip the white bread in the egg mixture, flip it over, and then you pull it out all sloppy gooey and throw it in the pan and cook it. When it's, 2 minutes, flip it, another 2 minutes. When the eggs are done on the bread, it's done. And then you dust it with powdered sugar if you want. But, French toast is amazing. It's absolutely wonderful. And just cover it in syrup or jelly or jam or whatever you want. It's good stuff. Just Google the recipe.
Have you had sufficient time to speak with Ms. Jewell about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by admitting you violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations?
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf?
Yes, sir.
You're waiving your right to testify to remain silent at the evidentiary hearing, which would be your decision to make?
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence?
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Ms. Bobby, do you feel the admission is in your best interest?
Yes, sir.
You agree you violated the terms and conditions of your probation by failing to report and absconding from supervision? I'll find there's a basis for the admission. I'm going to find that Ms. Bobby's admission was freely and voluntarily made after consultation with her attorney. I'm going to accept it. Her probation is revoked. She's adjudicated guilty of the grand theft. She is sentenced to 13 months in the Florida Department of Corrections, given credit for 93 days time served. All monies previously imposed and not paid are reduced to a civil judgment. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. That's also reduced to a civil judgment. Ms. Bobby, you have 30 days to file a notice of appeal. If you wish to appeal your judgment and sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, ma'am. You can step over and be fingerprinted.
Thank you, sir. Ms. Garcia? Our coming before the court is Lynette Garcia, case numbers 22 CF 3818 and 23 CF 936. As to 936, she'll be entering a plea of no contest to tampering with evidence and possession of paraphernalia, adjudicated guilty as to each, sentenced to 60 months of probation, court costs and fines in the amount of $1,078. 100 hours community service work, $20 a month cost supervision. She is to be bars to bed, Keaton, and aftercare. After she gets out of Keaton, she will be on drug offender probation for that entire term. Part motor vehicles may apply additional penalties. She'll be adjudicated guilty and time served on the paraphernalia.
We're waiting.
Stipulate to the facts and the probable cause affidavit, serve as a prima facie basis, and also agree to the minimum cost of prosecution. DNA sample, forfeit any seized items, and no contact with the co-defendant. As to the 22 case, she would enter an admission based upon her plea. She will be reinstated, extended to the full 60 months from her original sentence date.
Including
and again,
the
bars to
sugar?
bed, Keaton, and aftercare is to be applied in that as well. And the additional $250 court costs and fines.
Know the agreement with the state?
Yes, Your Honor.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, Ms. Garcia, you can lower your hand and state your name.
Lynette Garcia.
Ms. Garcia, you heard the announcement of Ms. Jewell, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning, which would affect your ability to enter the agreement or understand the terms
I'm gonna let the Aussies take that one.
and conditions of it?
No, sir.
I've been handing a plea waiver and consent form. There's the front of that document. On the back, it's the signature of the defendant line. Is that yours?
Yes, sir.
Have you had an opportunity to read that agreement?
Yes, sir.
Have you had an opportunity to go over your new case and your violation of probation with Ms. Jewell?
Yes, sir.
Have you had sufficient time to speak with Ms. Jewell about your cases?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by admitting you violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing?
Yes, sir.
And by admitting you violated the terms and conditions of your probation, you're waiving your right to have a trial.
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses that you might have to these allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial and at the evidence you're hearing, which would be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Ms. Garcia, do you feel the plea and the admissions in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
It says state or defense is not aware of any DNA evidence. Is that correct?
Correct.
Correct.
Ms. Jewell, you stipulated to prima facie case?
I would.
Okay. On case number 23 CF 936, I'm going to accept the stipulation, find as a prima facie case, and we'll find that Ms. Garcia's plea was freely and voluntarily made after consultation with her attorney. I'm going to accept it. She's adjudicated guilty of tampering with evidence and possession of drug paraphernalia. On count one, she's placed on a term of probation not to exceed 60 months.
I'm sorry, I don't know what Marmite is, but it just sounds like you got bit by something with 8 legs.
She's ordered to pay fines and costs of $1,078. She must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I will give the Florida Department of Corrections the discretion to amend that at the direction of the probation officer. Her cost of supervision will be $20 a month. It'll be drug offender probation, which will include random UAs at her own expense. She's to have no contact with any co-defendants. As a special condition of her probation, she'll enter and successfully complete the Keaton House and the aftercare program. This will be a bar at the bed, which means you'll remain in the Bay County Jail until a bed becomes available at the Keaton House. Any violations of the jailhouse rules or the Keaton House rules can serve as a basis for an affidavit of violation of probation. There is no restitution applicable in that case. In case number 22 CF, on the possession of paraphernalia, she's sentenced to 34 days in the Bay County Jail, given credit for 34 days time served. In case number 22 CF 3818, she is reinstated to probation. Her probation is extended 60 months from the original sentence date. It's modified as follows: if she'll enter, successfully complete the Keaton House, plus the aftercare program, bars to bed, all conditions that were previously imposed and not paid, or have not been completed or reimposed. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. This sentence will run concurrent with the sentence received in case number 23 CF 936. Ms. Garcia, you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you. You need to step over, be fingerprinted, and speak to the probation officer. Mr. Shepard.
Thank you, Judge. Your Honor, first case I have is Matt Albritton.
Mr. Albritton.
Judge, may Mr. James and I approach?
Sure.
I left this long pause in to show that they were fingerprinting people in the background because it was like the first really good glimpse of it. And oh my God, you guys. Oh, wow. Y'all had me just laughing so hard. Oh, yeah. You guys are great. I love you guys so freaking much. I can't even. What do you mean by that exactly? What do you mean by that? Oh, you guys, my stomach hurts. Like, My diaphragm like did way too much there. Oh, I know, Lord. Oh, I know. This is what it's like here. We just chill out and have a great time. We're just a whole bunch of friends. Yeah, that's what we do here. Yeah, but we got to be careful at our age giggling too much and we might accidentally glitter fart ourselves. Oh my God, y'all, I can't. I just can't. Oh my God. I don't have another clip prepared. So here's what I'm going to have to do. Because I ain't no way I can sleep now. Y'all are just too much. You're just too much. But I am aware of. This is what we did the last time. This gets to be fun. Whoa, hold up. Hold on. I don't know. I don't know if you guys can hear. I accidentally started YouTube and it started playing my channel. Come on. Do what I mean. Okay. I'm new to all this, so come on. We're going to share this. Yeah.
Your Honor.
Go ahead, Ms. Falk.
So sorry, Your Honor. Totally unrelated, just checking in to make sure those last 4 cases, they brought the defendants over for SAP.
Yes, this morning. Yeah,
Yeah,
this afternoon they did.
one of
We
my
finally
favorite things.
finished up with those cases about 20 minutes ago.
Okay,
So,
thank you so much.
yes.
We have, that is one of my favorite sayings. And then my other favorite saying is, those who know the least know it the loudest. Am I wrong? Am I wrong? I know I'm not wrong.
The SAP reset date is going to be September 12th. And courtroom 2, whenever you all are ready.
All right, we are ready.
Your Honor.
Yes, good afternoon, Ms. Abbott.
Good afternoon. So I was unable to speak with 4 of 5 clients today. I was wondering if I can get breakout rooms for them and I can place that in the chat.
Okay, go ahead and do that. And I don't know if
I guess I can just talk to them on the phone.
Okay, you might have to do that. I know that we have limited personnel at the jail, so let's see if you'll place in the chat which clients you're going to need to speak with, and we can start doing that. And maybe is Ms. Kim with you today?
Yeah, I think she may have the same issue, but I don't know if she was able to speak with anyone. She's on, looks like.
Also, Your Honor, I have one conflict, but I have not been able to speak with him yet.
Okay, that's going to be one of those days. That's fine. Okay, so courtroom 2, it appears. Ms. Kim, are you on with me?
I think she's talking to a client right now.
Okay, she's talking.
On the phone right here.
Okay, so it appears that most everyone of the public defenders will need to speak with someone. So I don't know how best to accomplish that. Do you have more than one phone there?
We will take Ms. Avidan's number, and she can make she can talk to some clients. But we had about 4 or 5 people already talk to somebody. Maybe it was Miss Kim, but
okay.
We definitely will for those whenever the court is ready. But we will take your number if you want to put your number in chat.
Okay, if you'll just put it in the chat so that they can call you. And when Miss Kim gets off the phone,
No
let's
room
take
for
her
that
number.
here.
And we also have Miss McLeod who's going to need to speak with her client. So.
And she also can put her number in the chat. I know she probably gave it to me earlier, but can't put it in chat.
Okay. Okay, so we'll be in recess until someone's ready to proceed.
You can't go to recess immediately after you start the calendar. That's not how that works. That's a terrible idea. Now I gotta find where he comes back from recess. Oh my goodness. That would have been a long wait.
Very good. And have you had the opportunity to interview everyone that'll be your client this afternoon, Ms. Kim?
Yes, I have. Thank you for being patient with us.
Oh, no, that's fine. I understand. The SAP calendar we just finished up about 30 minutes ago, so that required patience.
Thank you.
So courtroom 2, we're ready with Ms. Kim's clients whenever you're ready.
All right, I don't have a calendar, so I will call out their names.
Okay.
With Oliver. Oliver Tyrone. Oh, no, he's still talking. Philip. Philip, is you?
Philip Hills, they're calling you.
Come to the green chair. Okay.
So I think this is position number 8, Devonta Phillips, is that right?
Yes.
Yes. Good afternoon, Mr. Phillips. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
No.
We're doing this by video. Is that okay with you? Was that a yes?
Yes.
Thank you. You have been charged in case 23 CR 005238Y with simple assault family violence. Is there a history?
The defendant has 33 cycles. The defendant's last arrest was June the 29th, 2023 for criminal trespassing with the Georgia Tech Police Department. That case appeared to be still pending. The case number is 23 CR 004077Y. And the defendant does appear to be on probation in Cobb County for false imprisonment. That disposition date was October the 11th, 2017, and the term is for 10 years. In addition to that, the defendant appeared to be on probation in Fulton County for battery, family violence,
Not so much.
2 counts. That case number is 21 SC 178123. That disposition
Rona
date
really
was June the 30th,
took it off.
2021. 1 year of confinement and 2 years of probation. And also, he appears to have an outstanding hold out of Marietta, Georgia, for a probation violation. The date on that warrant is August the 2nd, 2023. The defendant does have prior misdemeanor sentences and convictions.
Toma,
The defendant received a
Wisconsin.
nolo contendere sentence in 2019 out of Gwinnett County for driving while license suspended or revoked. And there was one in 2017 out of Cobb County for simple battery. One in 2016 for battery, family violence. One in 2015 for criminal trespassing. And he does appear to have a
This guy's got a
history
long
of
rap sheet.
failure to appear. It's one in 2023, one in 2019, one in 2017, one in 2015. In addition to that, he has a history of probation violations, one in 2023, one in 2022, one in 2019, one in 2018, one in
I
2016.
have friends from all
Nothing
over the
in addition, Your Honor.
world.
Thank you, Ms. Jackson. Yes, good afternoon, Ms. Nemini.
Good afternoon, Your Honor. This incident happened last night at 247 Camila Lane, Northeast Atlanta. Officers were dispatched due to a call about a suspicious person at the location based on an email that the property manager has sent about a Black male in the area who was impersonating a security officer. And it sounded like the person was in a dispute with a Black female in front of the leasing office. Upon arrival, the officers noticed the person described in the call was the defendant. He was in a Black security t-shirt arguing with a woman holding an infant in her arms. Officers were able to chat with the victim, Ms. Valencia Watson, who advised officers that defendant had threatened her and pulled out a knife and that she had been trying to leave the area. Additionally, she told officers that they were at the gas station and defendant became irate due to the argument, and then defendant turned aggressive and was holding a pocket knife. And once the parties arrived at the apartment, defendant proceeded to slash her rear driver's side tires and threatened to stab her and making her feel unsafe. She did tell the police that he never put his hands on her or lunged towards her with the knife. However, nearby witnesses and neighbors say that she was on the balcony when she heard the dispute and heard the threats and saw a defendant being aggressive with her, but he did not hit her. When officers spoke with the defendant, he agreed that they were arguing but denied having a knife or threatening her, claiming that it was Ms. Watson, the victim, who was threatening him, and that she hit him in the mouth with the shoe. However, no witness corroborate those allegations, and no knife was found on his persons. Considering that defendant is a convicted felon, his criminal cycles range from 2012 to present. Bond is currently at $5,000, and the state is asking to increase it to $8,000 cash bond. No alcohol, drugs, or weapons, to stay away from that specific location. No further contact with Ms. Valencia Watson, which I would like to sound for when at the appropriate time, and family violence intervention program. And Your Honor, based on his criminal history, I have a simple battery from 2020 that you provided, and he took a guilty plea, and it was on the plea that he would have no further contact with Ms. Valencia Watson. Another family violence battery case, cruelty to children, where he was sentenced to 1 year confinement, and then another one out of Clay County in 2022. The state feels the $8,000 cash bond is more than reasonable considering his criminal cycles. And I would like to sound for Ms. Valencia Watson, who is on the call right now, Your Honor.
Ms. Watson, if you would like to address the court, I'll need for you to unmute yourself, and I'll have to swear you in.
I don't watch football.
Yes.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, ma'am. Thank you. What would you like to tell the court?
That I would like to just have a no contact with me, no contact with the children. And that like over the years, things have just been escalating. So like prior to, there was physical violence, and now there's weapons being involved. And so I definitely just want to just stay away from him.
Okay.
One with the plumeria flower, my favorite.
Anything further, Ms. Watson?
No.
Okay, thank you, ma'am. I appreciate it.
Your Honor, if I could interject,
yes,
I'd
like to ask Ms. Watson, are you in fear of your life? Are you in fear of the defendant? And
yes, I don't believe that he has self-control. And I'm hearing new things even today. Like I thought that he actually worked at the location. I was trying to be helpful, and it's like, yeah, sorry, there's a train. So I'll just leave it there. that I don't want to continue to keep this cycle going. It's been ongoing for a long time.
Yes, and Your Honor, the cases that I have cited, they have all included Ms. Watson. And the state will also like to add a third-party transfer for the children if you allow him to see his children, even though Ms. Watson disagrees. Yes, Your Honor.
Okay, thank you. Ms. Kim?
Yes, Your Honor. My client is 30 years old. He was born and raised here in Georgia. His mother's here. He has a place that is separate from Miss Watson. They don't live together, Your Honor. So we have no objection to stay away and no further contact at all. And he is willing to stay away. However, there are 5 children with her. 10 years old, 8, 6 to 10 months. My client wants to have a relationship. So we ask for a third-party transfer to make sure that he has a chance to spend time with his kids. He says that he actually works at that location, 2470 Camellia Lane. That's his workplace, the condo. He works as a security. He's been doing that for about a month and he wants to keep the job. He graduated from high school. He denies the allegation. He says this is completely false charge, that he is just extremely frustrated about. Your Honor, my client does not do any kind of drug.
I would meet Drew Brees just because he's an awesome, awesome person. Not because of the football thing. I mean, football's not my bag, but I'll go and watch and shout and cheer and all that other stuff, you know. I need to go fill my coffee cup first though. But yeah, I'm still all for going to a Drew Brees, game with you and meeting him and everything, but it ain't for the football. It's for the fun and people.
Or alcohol, and we would like to request that $5,000 surety bond remain as set. Actually, we want it to be decreased to $2,500 since he has a lot of financial challenges. Thanks, Your Honor.
Well, Ms. Kim, I am concerned that he has not only violated a court condition, he has violated one of my court conditions. And one of my court conditions, which placed him on probation, was that he was to have no further contact whatsoever with Ms. Watson. So it appears that he has not only violated that condition of something that I issued, and you know how I feel about that. As such, it's going to be a $5,000 cash bond, no further contact with Ms. Watson. He can only go back to the Camilla Lane address if he is actually employed there. He's to have a third-party transfer of any minor children for visitation, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor. Mr. Phillips, judge has ruled, please do not say anything. It will work against you. You have a right to remain silent, please. Call me if you have any question. Please call me later.
Whenever you're ready, courtroom 2.
There you go. Good afternoon, Your Honor.
Your Honor, Mr. Oliver,
Okay.
Ron Oliver.
This is position number 7, Mr. Oliver. Good afternoon, Mr. Oliver. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
So, Your Honor, salutations to you all. Thank you.
Thank you. Mr. Oliver, you've been charged in case 23 CR 005237A with battery family violence. Is there a history, Ms. Jackson?
The defendant has 16 cycles. The defendant's last arrest was November the 25th, 2019 in Fulton County for a failure to appear. The defendant does have one felony sentence. He received first offender treatment in 1994 for the violation of the Georgia Controlled Substance Act. A case was sealed March the 3rd, 1994. And he does have misdemeanor convictions. It's one in 2015 for affray, one in 2006 for criminal trespassing, one in 2005 out of Douglas County for theft by receiving stolen property, and one in 2003 for possession of marijuana less than an ounce, one in 1991 out of Cobb County for driving while license suspended or revoked, and one in 1990 for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. Ms. Nemini?
Yes, Your Honor. This incident happened May 16th of this year at 532 Cleveland Avenue, Southwest Atlanta. Officers, a 911 call was placed by the victim, Ms. Tanika Clark, which stated that she was being assaulted by her boyfriend at that specific location. Officers responded and took Ms. Clark's report and documented her injuries. The parties had gotten into an argument which upsetted the defendant, and he punched her in the face allegedly one time, but it resulted in a laceration above her left eye. Based on his cycle, the parties are in a relationship and they do live with each other. The state is asking for a $4,000 surety bond to stay away from that location if it's not a shared address. No further contact with Ms. Tanika Clark, no alcohol, drugs, or weapons, and 1 day of anger awareness.
Has your office had the opportunity to speak with Ms. Clark, Ms. Nemini?
No, Your Honor, not to my understanding.
And I don't see a Ms. Clark on the line, but if Ms. Tanika Clark is on the line and wishes to address the court, now is your opportunity to do so. Ms. McLeod?
Yes, Your Honor. My client is 61 years old. He is a native of Georgia. He tells me that he's a graduate of Atlanta Area Tech. He is the father of 2 sons who live at home with him at the present time, a 19-year-old and a 20-year-old. He tells me that the younger one, the 19-year-old, was shot multiple times and is essentially disabled. So he continues to be a dependent and he takes care of him at all times. So he's concerned because he tells me that when he's not around, his son tends to act out because he doesn't understand when he's not present. So he's quite concerned about getting back home to take care of him. My client denies that he is in a relationship with the alleged victim, Your Honor. He tells me that he's known her and they have been friends for upwards of 20 years. He denied that he struck her, Your Honor. He says that is absolutely not true. He also denies that they live together. He tells me that she actually lives in Alabama. And on that date, the 16th of May of this year, she just happened to be visiting. He got home and she was there with his sons. And she was about to do some drugs in his house. And he asked her to leave and discuss an argument, but he denies that he struck her. I would ask the court to consider giving my client, if not a signature bond, because I do understand that he has some history on it, but no history of violence based on what I heard, and certainly not of any domestic violence. If the court would consider a signature bond, but if not, a bond not more than $1,000 good bond would be what we'd be asking. Nothing further, Your Honor.
Your Honor,
Yes.
so the state was able to speak to the victim, and then she did clarify that they aren't in a relationship anymore, but they were, and they don't live with each other anymore. But the incident location is the defendant's location, so the state wouldn't be asking for a stay away. But she did want it on the record that she hasn't talked to him since this incident occurred, but she is in fear of the defendant and she does not want any contact at all. And I would like to sound for her in case she's here, because she did say she was going to be online today, Your Honor.
Okay, I believe that I already sounded for her, Ms. Nemini, but if not, if Ms. Clark is with us, now's your opportunity to speak. Okay, doesn't appear so. It's going to be a $3,000 signature bond through pretrial per the judge, 1-day anger awareness, no further contact with Ms. Clark, and no drugs, alcohol, or weapons while out on bond. Good luck. You're welcome, Ms. McLeod. Good luck to you, Mr. Oliver.
Thank you, Your Honor. That concludes this before the court today. May I be excused?
Yes, have a good afternoon. Thank you, Ms. McLeod.
Thank you, Judge.
Mr. Robinson, Jamal, Jimmy, Ms. Robinson.
Mr. Robinson is position number 9. Good afternoon, Mr. Robinson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Robinson, you've been charged in case 23 CR 005239G with willful obstruction of a law enforcement officer. Is there a history, Ms. Jackson?
Yes, Your Honor, this is going to be a bond surrender. The defendant has 4 cycles. The defendant's last arrest was July the 19th, 2023 in Fulton County for a failure to appear. The defendant does appear to be out on a signature bond through pretrial services for possession of marijuana with the intent to distribute. That case number is 23 CP 215373. There were no convictions listed in the GCIC. I do see an outstanding hold out of Orlando, Florida, for a failure to appear. The date on that warrant is May the 24th, 2023. Nothing in addition, Your Honor.
Thank you, Ms. Nemini.
Yes, Your Honor. This incident happened yesterday morning at around 2:30 a.m. at 808 McDonough Boulevard, Southeast Atlanta. Around 2:30 a.m., officers were dispatched to the location, which is also known as a Texaco gas station, in reference to a trespassing call. Upon arrival, the officer saw 15 to 20 males standing outside the gas station parking lot and near the gas pumps. The clerk that called stated that he wanted the parking lot cleared because the store had closed at 2 a.m. As the officer was clearing the parking lot, he noticed 2 males, one which is the defendant and another unknown male fleeing in the vehicle of which he was investigating at the location. As the officer approached the 2 males, he advised that they had to leave the premise. He was told that they were waiting for their Uber, and he told them that they would have to wait on the side of the building instead of the front of the building. And as the officer cleared the parking lot, he noticed a blue Kia Forte with a temporary Georgia tag left at the location with no one around to claim it. And he ran the tag and the vehicle came back to a red Nissan Sentra. And as the officer was investigating the vehicle, an unknown male approached the vehicle in an aggressive manner, asking why the officer was so close to his car. The individual was told that the tag was wrong, and the individual got irate and told the defendant to throw him the keys, in which the defendant threw him the keys, and that individual got into the car and opened the passenger doors for 2 other unknown males. The officer went to stop the other males from entering the vehicles, and one of the males was able to get inside and the vehicle sped off. And then the irate man ran towards Fisher Road, and the officer told the defendant not to move and to get on the ground, and then he was transported to jail. Bond is currently set at 10,000 surety. Your Honor, the state is asking to reduce it to 3,000 surety bond. If there's no conditions of alcohol, drugs, weapons, we ask that you add that. Stay away from the location at 808 McDonough Boulevard, Southeast Atlanta. And that's it, Your Honor.
Ms. Kim?
Yes, Your Honor, my
It
client
makes the
is
courts feel
24
better.
years old and he is currently residing with his mother. And Your Honor, he has a good solid location, address, and he's from Georgia. And he also has one daughter who is 2 years old that he is taking care of.
No,
They
his
live
mom has
together
a good
at this
solid
point.
address.
Your Honor, he's been going through a lot of job searching and he has interviews lined up. However, he has been unemployed for the last 1.5 months. So he does not have any income and no means to pay for any bond. So we would like to request for a signature on bond. And Your Honor, my client denies allegation about he just didn't know anything about it. He doesn't know those people. It was just he just tried to kind of do whatever the guy was yelling at him to give him the key. But anyway, we believe that 3,000 surety bond will be a very, very high for him. Thank you.
Okay, it's gonna be $1,000 surety bond. Stay away from the Texaco gas station on McDonough Street, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Robinson.
Thank you.
Mariah Cephas, Judge. This is Mariah Cephas.
Okay, this is position number 10. Yes, good afternoon, Ms. Cephas. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You've been charged in case 23 CR 005240A with theft by taking. Is there a history, Ms. Jackson?
The defendant has one prior cycle. The defendant's last arrest was December the 9th, 2022, for misdemeanor theft by taking in Clayton County, Georgia. There was no disposition for that arrest. The defendant does appear to meet the criteria for a UJR through pretrial services. Nothing in addition, Your Honor.
Ms. Nemini?
Yes, Your Honor. This incident happened July 9th of this year at 2947 River Ridge Drive in Atlanta. The officers were dispatched to a location concerning a larceny call. That defendant had taken Miss Deja Miller's Apple iPod headphones, her house, and her car keys. Upon arrival, the officers noticed that the victim was walking in the middle of the street, in which she informed officers that her ex-girlfriend, the defendant, was upset at her for attempting to leave the home after spending the night. So defendant had taken her keychains containing the AirPods, house keys, and car keys, and ran outside to hide in the backyard. And when Ms. Miller followed her outside, the defendant took off running down the streets and into the woods. When the officers got there and approached the defendant, she claimed she was afraid to come out in a chance that she would get arrested, claiming that the items were left in Ms. Miller's car, but after checking, they were not there and the car was still locked. And then the defendant did say that she placed the keys in the front part of the woods where she initially ran into the woods, but they were unable to locate those items. Ms. Miller provided the officers with cell phone footage with the missing items, and defendant refusing to return them while they were in her hands. On the date of the incident, to this day, the items have not been returned. The state is asking for a 3,000 signature bond through pretrial. No further contact with Ms. Deja Miller, no alcohol, drugs, or weapons or guns, and no stay away, because I believe this is the defendant's home, but if it's not, to stay away. And I would like to sound for Ms. Deja Miller if she is on the Zoom call today, Your Honor.
I'm an animal lover
If
too.
Ms.
They
Miller
taste
is
great.
on the call and wishes to address the court, now is your opportunity to do so. Does not appear so. Ms. Kim, if it's okay with you, it's going to be a $2,000 signature bond through the jail, no further contact with Ms. Miller, and no drugs, alcohol, weapons while out on bond. Does that suit you?
Yes, Your Honor.
Okay. Good luck to you, Ms. Evans.
Thank you.
You're welcome.
No, I'm sorry, with Oliver, yes. Come on.
Mr. Bracy, Mr. Aaron Bracy.
Position number one.
Good afternoon.
Good afternoon,
I
Mr.
couldn't
Bracy. I'm
resist.
Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Let's see, Mr. Bracy, you've been charged in case 23 CR 005245H with public drunk, criminal trespass, and willful obstruction of a law enforcement officer. Before I get the history, let me make sure that counsel for Mr. Bracy's on the line. Is this one of, is this your case, Ms. Kim?
No, I think this is PD Rachel Epton's case.
Okay.
I believe she's still interviewing other clients.
Okay. Do you have any other clients this afternoon, Ms. Kim?
No, I don't have any more.
So all the rest of the cases are Miss Abden's?
Yes, Your Honor.
Okay, so courtroom 2, we're gonna have to pause until Miss Abden is free. So as soon as she completes her interviews, we'll continue.
Thank you.
So Mr. Bracy, if you'll just hang on for the court until we get your attorney here, okay?
All right. Yes,
Thank
Judge.
you. Okay, we'll be in recess until Ms. Abden returns. Where we are, please.
I was told that she only has one person left, so almost done.
Okay, thank you, Ms. Kim.
Thanks.
Hello.
Okay, we ready to proceed?
Oh, I muted you. Thank you for your patience, Your Honor. I appreciate it.
You're fine, Ms. Abden.
So I am ready. I also need to request a breakout room on position 5.
Okay, we'll do that at the end.
Yeah, I figured.
Okay. So we had Mr. Bracy.
Sorry, it's so much more work to unmute myself and switch back and forth when I'm streaming it straight from the YouTube. But anyways, truth about veganism is veganism actually kills more animals than being a carnivore does. And the reason why is for those soybeans to grow, for all of the vegetables to be grown, the farmers have to go through and kill every mole, every vole, every mouse, every bunny, every little critter that is going to come through and try to eat those greens. And they come through, and what doesn't get chewed up and spit out, they'll come through and they'll Monsanto the crap out of everything and kill what's left. So vegans like to feel superior about the fact that they don't kill anything, when the reality is it's just like PETA. You know, it's really great in theory, but the truth of it is that they kill more animals than they save. I just had to throw that out there.
Before us, do we want to go back to Mr. Bracy?
Yes, that works.
Okay, and I was just about to get Mr. Bracy's history.
The defendant has 9 cycles out of Connecticut. The defendant's last arrest was October the 25th, 2017. in Connecticut for interference with an arrest and criminal trespassing. The defendant does have felony convictions. This one in 2017. Just said failure to appear. The underlying charge was not clear, Your Honor, in the conviction. There was one in 2012 for larceny, and there was one in 2011 for possession of controlled substance. And there was one in 2002 for assault on personnel, and there was one in 1999 for possession of controlled substance, and there was one in 1997 for no pistol permit. And he does have misdemeanor convictions. There was one in 2004 for assault, one in 2003 for DUI. Nothing in addition, Your Honor.
Thank you. Ms. Nimini?
Yes, Your Honor. This incident happened August 28th, yesterday at the Holiday Inn, which is located at 909 Holcomb Bridge Road. Defendant consumed multiple alcohol beverages before being cut off for his visibly impaired state. Defendant became verbally abusive to the bartender and the front desk staff. Defendant had red, watery eyes. His speech was slurred, and he had the odor of alcohol on his breath. Defendant was asked to leave by the front desk staff, which he refused to do. Defendant then failed to comply with the officer and refused to place his hands behind his back and threatened to F up the officer if his handcuffs were removed.
Not sure. Sorry.
The state is asking for the bond to stay the same, $1,000 per count, the surety bond preset by the judge. Stay away from Holiday Inn at 909 Holcomb Bridge Road, no alcohol, drugs, or weapons. The state was able to talk to the victim, who claims that they're in a relationship, they live together, and they share a child together. The victim confirmed.
Ms. Nimini, this is a public drunk, a criminal trespass, and an obstruction.
I apologize, Your Honor. I think I was reading the wrong.
Okay, I think so.
Yeah, I apologize.
Okay, no, you're fine. Anything further?
No, Your Honor, that's it.
Okay, Ms. Abden, if okay with you, it's gonna be a $500 signature bond through the jail on each charge, which makes a total of a $1,500 signature bond through the jail. Stay away from the Holiday Inn on Holcomb Bridge Road, and no drugs, alcohol, or weapons while out on bond. Does that suit you?
It does, but I do have a caveat. I wanted to know if we can make that a surety bond. It is my understanding that my client wants to return to Connecticut tonight, and he tells me a signature bond will take 2 days. I'm new to the county. I don't know if that's true or not. I do think that a signature bond would be best, but maybe Your Honor has more information on that for us.
From my understanding, if I give him a signature bond, he'll be able to sign himself out. And if it goes to the jail, he'll be able to sign himself out through the jail. And as long as he has an address, he'll return for his next court date. So if you want me to give him a surety bond, I'm happy to do that. But
that is my understanding as well, Your Honor. So I think a signature bond would be best, and I will let him know, and all of the conditions he agrees to as well.
Okay, very good. Good luck to you, Mr. Bracy.
Thank you.
Thank you, sir.
You're welcome.
It'll be late on. Who's next, Judge?
You tell me.
You want to just, okay. Mr. Miller?
They have to make a new
Position
batch.
number
County take
6,
them all.
Mr. Miller. Good afternoon, Mr. Miller. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Miller, you've been charged in case 23 CR 005236A with simple battery. Is there a history, Ms. Jackson?
Yes, Your Honor. The defendant has 4 cycles. The defendant's last arrest was April the 25th, 2022 in Douglas County for burglary and criminal damage to property in the second degree. There was no disposition for that arrest. The defendant appeared to meet the criteria for a UJR, Your Honor. Nothing in addition.
Okay, Ms. Nemini?
Yes, Your Honor. This incident happened yesterday at 3030 Continental Colony Parkway in Atlanta, Georgia. Officers arrived at the location based on a dispute call that was, and they made contact with the victim and the girlfriend of the accused, Miss Ariel Burris, who advised officers that the defendant had punched her when she asked him what he was looking at on his phone. She advised officers that defendant had been watching porn, and when confronted, denied it and argued to the point that he punched her. Nearby witnesses, the leasing officer and the caller, the person who called Miss Alicia Young, saw the incident and saw Miss Burris attempting to leave and defendant grabbing her and pulling her back into the apartment. The officers didn't notice any injuries. And I would like to sound for Miss Ariel Burris if she is online today. The state is requesting a $3,000 surety bond, no alcohol, drugs, or weapons, to stay away from that location, and no further contact with Miss Ariel Burris, Your Honor.
I see Ms. Barris on the line. Ms. Barris, if you would like to address the court, now is your opportunity to do so. You, of course, do not have to address the court, but if you would like to speak, you'll have to. There you go. Can you raise your lower your camera a bit, Ms. Burris?
Yes.
There you go. And raise your right hand for me. The other one. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Yesterday it was just a simple altercation. I had assumed he was looking at and doing things that I didn't approve of, and I
Your
started
Honor, I would
arguing.
object to the witness discussing the facts of the case.
Okay, in this court, Ms. Abdom, I will have anyone that wants to speak to the court regarding the matter tell me what they would like to tell me. I'll give you the opportunity to cross-examine them.
No, I'm gonna actually pull it up. We're gonna take a little quick break here for 1 second. It's like a minute and a half long video. Y'all, I'm not kidding. It was wild. Okay. Hold on. Let me get this put into place. And now this is some science fair bullshit here. What is going on? All right. No, this is some science fair bullshit here. What is going on? Oh, man. I can't, I don't have enough hands. Like, seriously. But I scraped inside of this to get the oil out, right? And it's shooting. Like, it was worse before, but look at that. Like, it's freaking little mini explosions. That is so weird. Okay, Debs, what made it happen? I'm like in a trance right now. I mean, look at the corners of this spatula. All I wanted to do was make some brownies, and now I got some science fair shit going on here. This is just tripping me out, man. I was making brownies. That is so cool. Look at the corners of the spatula. It was literally
it
just
was way more
shooting.
intense.
No. No.
You know, when I first scraped the cup, that's what got my attention. I mean, this is a dumbed down version of what I was seeing. I mean, it was literally like shooting out the side, like straight off. Like 90-degree angle off this spatula, just straight up in the air, and it was just coming off of it like this, completely sideways while this was upright, just shooting off.
Yes,
that is messed up. And like this oil, it's oil and water because I already put the 3 tablespoons of water in here, so
it's on my
it was
channel.
just oil. And I don't know if it would do it, you know, with the oil water combo, and that would be, you know, cheating. But yeah, I think the water is too heavy for it. It's gonna drip. But anyways, that was messed up. That was pretty cool. I really liked it.
No, that wasn't it.
And I thought I would share it with you guys.
No, so
'Cause
Deb,
I'm not just
pay attention, Deb. Look at, you can see that streak right there. Like,
bare bullshit here.
That was crazy.
What is going on?
Okay, so yeah, I had to share that with you guys because that blew my mind. So the only thing that I can think of is it called for 2/3 cup of oil, right? And so I filled it, you know, almost to 2/3 with vegetable oil, but I ran out. And so I used like 2 or 3 tablespoons of avocado oil, and I know they have a different weight. And avocado oil can burn at a much higher temperature than vegetable oil and not burn. But the only thing I can think of is that it was the 2 different weights that caused it to do that. But it was crazy. It was Deb, go watch the whole video. It is on my channel. Don't forget to like it. Yeah, it was really crazy. I'm still just baffled by it.
If you would like to. And anytime you have anyone that you want to present to the court for me to hear from, I'll give you that opportunity also. But I'll let Ms. Burris tell me whatever she wants to tell me in this regard.
Thank you, Your Honor.
Go ahead, Ms. Burris. And again, if you can lower your camera a bit so that we can see your face, please.
Oh, I'm sorry.
Okay, go ahead, ma'am.
Yes. So long story short, I became the aggressor. He never put his hands on me, but the altercation did stumble outside, but we were just arguing and the neighbors seen what was going on. He was bringing me back inside so it wouldn't be outside.
Okay.
He never put his hands on me or threatened me or anything like that.
Okay, and you did not call the police?
No.
And has this ever happened before?
No, sir.
And you're not afraid of him?
No.
Okay. Anything else that you'd like to tell me?
No, sir.
Okay,
It's a
thank you, Ms. Burris. We
5-year-old
appreciate you being here this
spatula.
afternoon.
Thank you.
You're welcome. Yes, Ms. Abden.
No cross. Thank you, Your Honor.
Okay, anything regarding Mr. Miller?
Yes.
Okay.
So Mr. Miller is 25 years old. He's lived in Georgia his whole life. He graduated from high school. He works at CKS Bottle Factory. He does maintenance. So he recently moved back in with his mom to take care of her. He's the sole breadwinner and the primary caretaker for his mom. She can't work because she has severe health issues. And so given that Ms. Burris is not afraid of him, he does not reside at this address, I would ask for no violent contact. He's okay with not returning to this address, and a signature on bond as he meets the criteria for unsecured judicial release.
Okay, it's going to be a $3,000 signature bond through pretrial per the judge, 1 day anger awareness,
their
no further
bullshit.
violent contact with Ms. Burris, and no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Miller.
Thanks.
You're welcome. Ms. Collier next. Okay, Ms. Collier's position number 2. Yes, good afternoon, Ms. Collier. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Collier, you've been charged in case 23 CR 005242Y with battery family violence. Is there a history, Ms. Jackson?
The defendant does not have any prior arrests on file, Your Honor. The defendant appeared to meet the criteria for UJR to the jail. Nothing in addition.
Okay, Ms. Nemini?
Yes, Your Honor. This incident happened August 26th at 3225 Matador Court, Apartment 8 in East Point. Officers met with Mr. Frank Rozier, who is the victim, who stated that he resides at the location with the defendant and his girlfriend. Mr. Rozier stated that him and the defendant got into an argument about the defendant's sister moving out. And then Mr. Rozier punched his computer and the defendant got mad and punched him in the face. Officers observed a deep laceration to Mr. Rozier's right eyebrow. Considering I think this might be her first arrest, the state is asking for a $3,000 signature bond through pretrial services. A stay away from 3225 Matador Court, Apartment 8. No further contact with Mr. Frank Rozier, no alcohol, drugs, or weapons. And the state was able to speak to Mr. Frank Rozier, who confirms they are in a relationship, they do live together, and they do share a child. Mr. Rozier said that this never had happened before, and he's not in fear of the victim, of the defendant, but he does want contact with the defendant, and he wants her to return back to the home. Mr. Rozier is online today, but the state is requesting no further contact with Mr. Rozier, with Mr. Frank Rozier, even though Mr. Rozier wants contact. And I would like to sound for Mr. Rozier.
Mr. Rozier, if you're on the line and you wish to address the court, now is your opportunity to do so. Is this you on the iPhone
I'd
here?
like to sound for the person
Yes, I'm on.
going to
Okay, can
contradict
you
what
raise your
I'm
right hand for me,
requesting.
sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, what would you like to, you can put your hand down, sir. What would you like to tell me?
I want her to
Wisconsin.
return home.
Okay, has this ever happened before?
No, sir.
Are you afraid of her?
No.
Okay, anything else you'd like to tell me?
I would like for her, if you can, to get a signature bond.
Okay, anything else?
No, that's it. Really.
Okay, well, we appreciate you being here this afternoon, Mr. Rozier. Ms.
No
Allen,
problem.
okay, if it's okay with you, it's gonna be a $3,000 signature bond through pretrial per the judge, 1 day anger awareness, no further violent contact with Mr. Rozier, and no drugs, alcohol, or weapons while out on bond. Does that suit you?
Thank you.
Yes.
Sounds
but,
great. Thank you, Your Honor.
Okay, good luck to you, Mr. Rozier, and you also,
I
Ms.
have
Collier.
one more question.
Yes, sir.
Is she gonna be able to return back home?
Yes, sir. She's to have no further violent contact with you, so she can return to your residence. Okay.
Okay, today?
As soon as
Signature
she's
bond.
processed out of the jail, so I'm not sure when that's going to be, but we'll get the paperwork in and she'll be processed out either today or tomorrow. Okay.
Okay, thank you.
You're welcome, sir.
All right.
Hi. Thank you, Miss George. Come on, Miss George.
Your Honor, we would need a breakout
is-
room for Miss George.
Okay, you want to do
Okay.
it fast?
So
Yeah, I
can we take Miss George last? And
Okay, I got you, Judge.
okay, thank you.
Your Honor, I just want to ask, there wasn't a stay away for Ms. Collier, correct?
No, there was not. It was no further violent contact.
Okay, thank you.
Yes. Okay, and this is Mr. Frazier, positions number 3 and number 4.
No, Mr. Ibrahim.
Oh, this is Mr. Ibrahim? Okay.
Your Honor, I just wanted to confirm, we received an email stating that this was a DA transfer. So I did not conduct an interview.
I don't have a Mr. Ibrahim on the calendar.
Okay.
This afternoon.
Thank you.
I feel like
Is this a
I've
felony
seen
transfer,
Mr.
Ms. Wall?
Ibrahim before.
Yes, Your Honor, and I can give the court the CP number. The CP number is 23 CP 221406. And that was transferred this morning at 10 a.m. to the felony first appearance calendar.
Okay, thank you. So Mr. Ibrahim will be seen by felony first appearance at a later time.
Saves on cost.
All right,
Yeah,
Mr.
I'm not
Frazier,
sure.
next, Judge.
Okay. Good afternoon, Mr. Frazier. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Frazier, you've been charged in case 23 CR 005243G with theft by shoplifting and criminal trespass, and in case 23 CR 005244G with loitering and prowling. Is there a history, Ms. Jackson?
The defendant has 32 cycles. The defendant's last arrest was October the 25th, 2022 with the Georgia Department of Community Supervision for a probation violation. The defendant does have prior felony convictions. This one in 2019 out of Cobb County for possession of methamphetamine. One in 2017 out of Newton County for entering an automobile with the intent to commit a theft. And he does have misdemeanor convictions. This one in 2019 for theft by receiving stolen property. And one in 2018 out of Jasper County, Georgia, for theft by shoplifting. One in 2017 out of Newton County for simple battery, family violence. And one in 2016 for theft by shoplifting. And one in 2010 for driving without a valid license. The defendant does appear to have an outstanding hold out of Blue Ridge, Georgia, for a failure to appear.
Dangerous.
The date on that warrant is January 26, 2023. In addition to that, he does have a history of probation violations. There were 2 in 2022, 1 in 2021, 1 in 2020, 1 in 2019, and 1 in 2018. Nothing in addition, Your Honor.
Thank you, Ms. Nemedy.
Yes, Your Honor. For the theft by shoplifting and criminal trespass that occurred June 10th of this year at 4735 State Road 138 in Union City, also known as the Walmart. Defendant went inside the Walmart with a backpack and concealed $123 worth of merchandise in the bag. Defendant had had previously been given a criminal trespass warning on January 19th of 2023.
Seriously? Who is still stupid enough to steal from Walmart? For real? They have better camera systems than NASA. Walmart can see a booger in your nose from the camera on the ceilings. So, like, why? They can read the UPC codes from the items in your cart. Like, I'm serious. They don't spend billions of dollars on their camera systems to allow you to fill your backpack with $123 worth of their shit. Stupid. Stupid. Oh, I did not just hit that button. Oh my God. All right. I know it was after the creepy iPhone guy. It was some dude in a white shirt. It wasn't that guy though. Yes, I did it again. Oh, this guy. It was this guy.
Shoplifting and criminal trespass, and in case 23 CR 005244G with loitering and prowling. Is there a history, Ms. Jackson?
The defendant has 32 cycles. The defendant's last arrest was October the 25th, 2022 with the Georgia Department of Community Supervision for a probation violation. The defendant does
Probably
have
see
prior
your
felony
brain
convictions.
through your nose.
One in 2019 out of
Some
Cobb
powerful
County
cameras.
for possession of methamphetamine. One in 2017
Meth.
out of Newton County for
Meth was involved.
entering an automobile with the intent to commit a theft. And he does have misdemeanor convictions. It's one in 2019 for theft by receiving stolen property, and one in 2018 out of Jasper County, Georgia, for theft by shoplifting. One in 2017 out of Newton
Lawyer
County
Kitty just
for
jumped
simple
off
battery,
this
family
bed and
violence,
disappeared.
and
I
one
don't
in
know where he went.
2016 for theft by shoplifting, and one in 2010 for driving without a valid license. The defendant does appear to have an outstanding hold out of Blue Ridge, Georgia, for a failure to appear. The date on that warrant is January 26, 2023. In addition to that, he does have a history of probation violations. There were 2 in 2022, 1 in 2021, 1 in 2020, 1 in 2019, and 1 in 2018. Nothing in addition, Your Honor.
Thank you, Ms. Nimini.
Yes, Your Honor. For the theft by shoplifting and criminal trespass that occurred June 10th of this year at 4735 State Road 138 in Union City, also known as the Walmart. Defendant went inside the Walmart with a backpack and concealed $123 worth of merchandise in the bag. Defendant had previously been given criminal trespass warning on January 19th of 2023. And then for the loitering and prowling and criminal trespass, that occurred June 27th of this year at 4947 Cottage Grove Place, Union City. Officers met with Mr. Lionel Smith, who stated that he chased defendants out of his backyard. Mr. Smith has previously filed a theft report 3 days earlier for someone stealing scrap metal out of his backyard. On that current day, Mr. Smith saw a defendant carrying scrap metal and confronted him. Defendant dropped the metal and took off running. Mr. Smith, the victim, chased defendant to the Family Dollar, where police were contacted and defendant was arrested. And then defendant was transported to the hospital and then released instead of going to jail. Defendant is currently being held on 2 counts of entering auto 23 CP 221 3AA for felony first appearance in a foreign county hold from Fannin County. Considering that I see 1, 2, 3, 4, 5, 6 parole violations, the state is asking for the theft by shoplifting, criminal trespass to reduce it to 2,000 shorty bond, 1,000 for each count. To stay away from that, Walmart 4735 State Route.
I haven't been paying attention to the iPhone screen for a minute now. What the hell is that?
Anti-theft course. For this, for the second case, the loitering and prowling and criminal trespass, there's a 2,500 shorty bond already preset, but the state wanted to add the current charge and reduce it to 2,000 for each count. So 2,000 surety bond total to stay away from the 49, 47 Cottage Grove Place, Union City, and no alcohol, drugs, or weapons, Your Honor.
Okay, just so I'm clear on position 4, my calendar only has the loitering and prowling. Do we have another criminal trespass? Ms. Bridgewater, do you have that?
No, I just have loitering and prowling.
Okay,
Your Honor, just to clarify, the state did file both and filed them down. I'm not sure if this is part of the issue with when charges have been added. We've been having some issues with Odyssey pulling both charges down when new charges were added.
What is in the
okay, I just want to
bottom
make sure that we give them a
right-hand
bond for
side
everything
of
that
the
we have
screen?
on there. So,
The hell
okay,
is
so we
that?
added on, thank you, Ms. Abden.
Thank you, Your Honor. And just to clarify, so on position number 4, we're adding a criminal trespass, correct?
It's my understanding that the state has added the criminal
Yeah,
trespass.
that's what I meant to say. I apologize.
No, you're
Okay,
fine.
thank you. So Mr.
I'm so
Frazier is
confused.
33 years old. He's from Georgia, lived here his whole life. He has his GED. He tells me that he currently is living with a friend named Cody, who he works with. They run an eBay store and he handles the shipping. His friend recently had him come move in with him and do this work with him to get him out of trouble. And he's been doing really well. He has 3 children. And he also tells me that due to a stroke that he had 8 years ago, he doesn't have
No,
any
I think
strength
he
in
was
his
wearing
left
cutoff
hand.
shorts.
And so that's made working hard, and that's why this job and this place to live is crucial for him. I would ask that the surety bond of $2,000 would be reduced to a reasonable amount of 500 on each for both cases, or lower if the court is inclined. My client does not have the means to afford that. And I understand he has other felony charges and likely won't get out today, but I'm just asking for a more reasonable amount.
Okay. For position number 3, the theft by shoplifting and the criminal trespass, it's going to be a $500 good bond per charge, makes it for a total of $1,000 good bond. Stay away from the Walmart on State Road, and no drugs, alcohol, weapons while out on bond. For position number 4, the loitering and prowling and the criminal trespass, it'll be a $500 good bond on each count, makes for a total of $1,000 good bond. Stay away from Cottage Grove Place, no further contact with Lionel Smith, and no drugs, alcohol, or weapons while out on bond. If he does not make bond by September 12th, which is the SAP calendar, if you'll have whomever's representing him, Mr. Abden, inform the court as to his other charges, and we'll either take a look at modification of the bond at that point in time if something happens with those entering auto charges. Okay?
Thank you, Your Honor.
All right. Good luck to you, Mr. Frazier. Let's see. And I believe the last one left is Ms. George, where we need a breakout room. So if myself, Ms. Abden, Ms. Falk, Ms. Kim, Ms. Nemini, if we can be placed into a breakout room. Yes, I said Ms. Falk.
Okay, Judge.
Thank you, Ms. Grace. I wouldn't leave you out, Ms. Falk.
Thank you, Your Honor. I must have missed my name.
No worries.
That would be a problem. And speaking of which, guys, I've got to be awake in about 5 hours ish. So I need to get sleep. I have two. One is Earl Grey, which is my grand kitty. And then the other is Billy O.T., which is my baby, the one that I was just cuddling. So I am going to say good night. This is almost over anyways. Man, I cannot thank you guys enough for coming out. Seriously, you guys have been amazing and wonderful, and I love you all so much. Like, thank you so much. You guys have a wonderful night, and I'll see you all soon.